May I permitted to mention before your lordship for contempt application?
Yes.
Your lordship, you are going to mention application for restoration. File is here because when before I mentioning before your lordship, and your lordship directly sub the copy, but my lord, it is a group 2 matter. Group 2.
But then this court does not have determination.
In the application for restoration.
Yes, but it will be before the regular bench.
Regular.
Yes.
For non-prosecution, my lord, I have served the notice.
Non-prosecution under which head? Under which group?
Group 5, my lord.
Group 5. Panchayat, cooperative society or municipality?
Municipality.
Municipality group 5. You have served notice upon other side. Whether the matter is appearing in the list?
No one.
It is matter is not appearing in the list. We will hand over the slip next Monday under the heading to be mentioned, sub notice.
Lordship, may I leave to mention one contempt application which I mentioned on December before 20, and lordship direct me to serve the notice. Matter will be come in the monthly list of January. Despite direction, that has not been come. Milord, again I mentioned the matter before lordship on January to fix the matter on February monthly list. Somehow it has been escaped on earlier occasion. Milord, today, Milord, they are, despite direction, they are doing construction and several violation of justice, Milord, which is for which I mentioned your matter. This is the serious case, Milord, where some lady who near about 89 years old suffering. They are encroached.
You have filed a contempt application.
Contempt application rule has been issued. They filed one frivolous affidavit, Milord. That affidavit has been challenged. Milord, matter has been come before lordship kindly, because it is my humble submission before lordship, so that any
if it is an illegal construction, it will be demolished.
Lordship,
wait for some time, let it appear in the monthly list of February under the heading
lordship,
contempt.
Lordship, it is my humble prayer, Milord.
Sorry, contempt application in this way.
Kindly take it.
No, the contempt application will not be taken up in this fashion. It is a contempt application. You hand over the slip, it will appear in the monthly list.
Make it on first item of the.
It will appear in the monthly list. No upgradation. Sorry. Yes.
May I submit this?
No. This contempt application, if it is found illegal construction, accordingly necessary order will be passed. You hand over the slip. Please don't waste court's time.
My lord, this is also contempt application.
It will appear. দিয়ে দেবেন তো February list. Yes.
Restoration application. My restoration application was filed in the month of July 2023. Despite this is the second time I'm mentioning before your lordship. Lordship will let it.
When petition was dismissed for default.
It was in the month of July before Justice Amrita Sinha.
When you have filed, it is whether you have filed restoration within time. Under which group?
Under group 5. It's a Panchayat matter, lordship.
Hand over the slip. Serve notice upon other side. Monthly list of March.
Lordship mentioning
Yes.
for contempt application. Contempt application. Contempt application, my
Contempt application arising out of the order passed by which court? Next.
May I permitted to mention, my lord, the Panchayat.
Come ready and mention. Yes.
My lord, Panchayat pension matter, my lord. My lord, 83 years old lady has come before your lordship for getting her family pension. My lord, I have served the notice to the other side. My lord, 535 in the monthly list of combined monthly list that was running. My lord, kindly.
Panchayat under which heading?
Under
hearing, under the heading.
No, my lord, this is under motion, my lord.
Hearing matter.
Yeah, hearing, my lord, motion stage.
When the employee retired?
My lord, retired long years.
What is the date of retirement?
Date of retirement, my lord, exact I will not.
Let it appear in the list. No upgradation. Sorry. Yes.
Contempt application. Rule issued by my lordship.
Application.
Contempt. Yes.
Contempt. Rule order passed by which court?
By the Honorable Justice Ashok Dasodikar and rule issued by my lordship.
Monthly list of February.
Contempt matter, my lord, old matter, my lord, matter Honorable Justice Monoranjan Malik in 1991. Thereafter.
What for you are mentioning?
My lord,
what for you are mentioning?
Contempt matter.
1991 order. What you are doing for such a long time?
My last occasion, my lord, matter was listed on 10th July 2018.
Before which court?
Dr. Shambhuddha Chakraborty.
What you are doing for such a long time?
My lord, this is a transfer bill, my lord. Right now, petitioner engaged me in that.
Month list of March.
Lordship, illegal construction 2021 matter, Lordship. KMC matter, Lordship.
Yes,
Lordship, KMC.
KMC matter,
KMC
illegal
matter.
hearing matter.
A new motion stage, Lordship, never taken up for.
What is the year of the writ petition?
2021, Lordship.
2021.
Lordship.
What was the order passed last by this
No order.
by the coordinate
No
bench?
order has been passed, Lordship. Never the matter came.
So if
came
it
up
is an
for-
urgent matter, why you are
Lordship, I
mentioned
mentioned before the coordinate bench, Lordship, but anyhow the matter could not be
So
listed.
it is at the motion stage.
Motion still, Lordship, the widower, now she is a widow, Lordship. Recently
Month
her-
list of February under the heading
I'm so
municipal.
grateful, Lordship. I'm
Yes.
so grateful.
Serve no, have you served notice?
I have
upon us,
served
right?
the notice.
Yes.
I have served them.
May I be
Gratitude.
permitted to mention, my lord?
Yes.
My lord, one restoration application. My lord, the matter was dismissed for default on 22nd of November 2022. My lord, the brief has been returned. There has been a change
When
of
the restoration application filed?
application was filed on 17th of October 2023.
Within time.
No, there is a limitation.
Have
Section
you
5.
filed section 5
Yes,
application?
Section 5 is also filed.
It is under which group?
It is under, my lord. Panchayat matter, my lord.
Panchayat matter.
Yes, my lord.
You have filed section 5.
Yes,
Have you
section-
served notice upon other side?
Yes, my lord.
Those who are representing the respondents?
My lord, respondent, respondent, my lord, there is no instruction about the
Serve notice and then mention.
service.
Serve notice and then mention.
My lord.
Yes.
Arising out code number 755. Justice Rajarshi Bharadwaj.
Past writ petition was filed by disposed of by Justice Bharadwaj, or contempt application was heard by Justice Bharadwaj?
Matter is enlisted in the court.
Contempt application has arisen out of the order passed by which court on which date? Come ready, please.
13 June 2018, Shamapti Chatterjee, Justice Shamapti Chatterjee.
What is the stage of contempt?
Oh.
Whether the rule has been issued?
Yes, my lord.
Come ready, please, madam, come ready. Don't waste court's time. Yes.
9 motion, my lord. 9, 2020.
Group 9 motion.
9 motion.
2020.
20.
It has not been heard.
My lord.
February monthly list under the heading Group 9. Have you served notice upon other side?
Well, motion, my lord.
Motion.
First time, my lord.
Very good. Motion.
My lord, may be permitted to mention on contempt application, my lord.
Yes.
My lord, contempt on the order passed by Honorable Justice Nadira Pataria, my lord. Her lordship there was. My lord, notice has been served, my lord.
What is the stage of contempt?
My lord, it is pending, my lord.
Whether the rule
It
has
is
been
hard-
issued or not?
Yes, my rule has been issued. That is WPCRC number 267 of 2012, my lord.
Who is appearing for the contempt now?
My lord.
Have
But
you
let's
served
take
notice
now.
upon the learned advocate representing the contempt now?
Yes, my lord.
Show me the notice.
দেখো
তো নোটিশটা। Month list of February.
Grateful lords.
Call the list. Item number 1 from appellate side, Delhi cause list.
I am appealing for the petition, my lord.
This has come up for correction from the department.
I'm sorry, my lord, on the last occasion I could not appear, my lord.
For their contempt.
Contempt application to one of bites. Issue.
But the can already been
Matter has
disposed of.
come up from the
Disposed of,
department
yes, sir.
for correction of the order dated 19 January 2024. Wherein the number of the application has been inadvertently described as IA number can 1 of 2023 instead of IA number can 1 of 2022. Stop. Next paragraph. Number of the application in the cost title of the order dated 19 January 2024 number of the application in the heading of the order dated 19 January 2024 shall be read as IA number can 1 of 2022. Stop. Next paragraph. Department is directed to incorporate necessary correction. Stop. This order shall form the part of the order dated 19 January 2024. Next.
Item number 2.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Same situation prevailed on 22nd January 2024. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Interim order finish stands vacated. Urgent xerox certificate copy. Next.
Item number 3.
My lord, I appear for the KMD. This one or 225.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Same. However, Kolkata Metropolitan Development Authority is represented by learned advocate. Stop. Next paragraph. Same situation prevailed on 22nd January 2024. Stop. It appears petitioner has lost interest. Writ petition stands dismissed. Interim order finish stands vacated. Urgent xerox certificate copy. Next.
Much.
Item number 4.
Well, I'm for the case.
I'm for the municipality, my lord. In this matter, my lord, your lordship on the last occasion gave us no time to address your lordship because, my lord, we took the point that in view of the word may used in section 218, there is a discretion not to demolish. Your lordship pointed out that Ghanoshyam Das judgment has taken care of the previous judgment and diluted the previous judgment. A very small submission on that, my lord. Ghanoshyam Das judgment has taken care of. In my humble submission, my lord, it cannot. Ghanoshyam Das. The ratio of the my lord.
Yes.
Because in this case, my lord, the commissioners considering the minor judgment of the
Yes, I have Ghanoshyam.
your lordship. So, my lord,
CLT report you have
these
brought?
are the SCC online report.
Yes,
My lord.
yes.
Now, my lord, here, my lord, in how it has been dealt with, my lord, the previous judgment. The only ground is that in view of repeal of the previous act, the judgment is no more a good law. That is not what has been held in Ghanoshyam Das. So far as Purushottam Lal is concerned, 72 Calcutta. It has been considered. I'll just not place that portion where it has been considered. Because previously,
the view was that the word may confers the discretion to demolish or not to demolish, not regularizing the construction, but not to demolish. I'll not demolish this portion. But that has been held in Ghanshyam Das to be mandatory. May has to be read as shall demolish. And your lordship will find out this SCC online version, my lord, there's no paragraphs. I'm just reading that portion, my lord.
Purushottam Das, Purushottam Lalji, three judgment of the High Court. That is in the context of 1951 Act.
51 Act.
Yes.
But the language which has been interpreted,
Maybe.
that is, my lord,
Maybe
same
much
as-
water has flown to river Ganges in the meantime.
True.
There is a mushrooming of unauthorized constructions. And not only this, the power which the municipal commissioner has, that has been divested by the Act of 1980.
80 Act.
That has been held by this
Yes,
in
yes.
Ghanshyam
Yes,
Das in a particular
may I
paragraph.
read? I have that.
Just a minute.
It says not the principles of law. May I read not that particular portion?
Just a minute.
My lord.
And Ghanshyam Das was considered by this court. In Purushottam Lalji was considered by
Considered, yes,
Ghanshyam Das.
That portion I
It was
want
not
to
a pari infinitum judgment.
No. Considered, and it has been held. I'm reading
And
the paragraph.
Ghanshyam Das was tested before in SCAG matter before the division bench. Division bench did not
Did not
interfere.
interfere with this.
Do you know that?
That judgment I have not gone through, my lord, but
Yes.
so, my lord,
In SCAG, Ghanshyam Das was tested, and that is on a particular facts and circumstances of the case. A separate order was passed by the honorable division bench, remanding the matter back to the concerned authority for reconsideration. But the law laid down in Ghanshyam Das has not been diluted.
Was not diluted.
Just a minute, let me find out
My lord.
that particular part of this judgment.
Page 10.
Yes, come
Well-
to the paragraph which starts with sentence with regard to the fourth issue.
With regard to the fourth issue,
Fourth issue.
my lord.
Then you need not read
My
read it in its entirety.
My lord. Last few lines. The principles of law in Purushottam
No, just a minute. Yes, the principle of law.
versus Ratan Lal, AIR 72 Calcutta, wherein the full bench, while considering the provisions in section 414 of the Calcutta Municipal Act 51, held that the municipal authorities had the power to exercise discretion are not applicable to the cases in hand, as the municipal commissioner has been divested of such power in view of section 635 of the Kolkata Municipal Corporation Act 1980, repealing the 51 Act. So that act was repealed.
Have you gone through the judgment of Purushottam Das Lalji?
Yes, I have that judgment with me. My lord.
There also a special circumstances has been considered.
Yes, my lord.
Show me that judgment.
Right.
Copy
Compliment. Let's say AIR 72 Calcutta, 459.
Copy nahi.
Reported judgment. Not paragraph. You'll also kindly come to paragraph 7. Facts have been stated. Then what paragraph is section is, my lord, quoted.
That is in this context of section 414 of 1951.
My lord. There, my lord.
Just a minute. The circumstances under which this judgment was delivered, that needs to be considered.
My lord. My lord.
Yes. Just a minute.
Paragraph 7, my lord.
Yes. Paragraph 7.
My
The
lord.
owners of the offending building as well as adjoining building were heard.
Heard.
heard, then please read it.
Thereafter, on 16th of May 1962, the commissioner passed the order mentioned herein before. It is apparent that the existing sloped roof of the room on the 4th story had been demolished and the height of the walls of the said room on the western side had been increased by only 2 feet and a flat roof or terrace had been built in its place. According to the superintendent, there was no serious infringement or violation of any.
Yes.
There was no serious.
There is such consideration in your order.
Uh,
And that is in the context of 414 Act, Section 414 of 1951 Act.
51 Act.
And in view of Section 635 of 1980 Act,
Yes.
the commissioner has been divested.
That
of the
power is
power.
gone. That power
And
is
not only this, the situation was completely different in 1972. Now, if this retention order is permitted to be retained on record, there will be a massacre so far in the administration of municipality. I won't permit this.
No, this is my limited submission. That the language of not 414 is similar to 218, and that was interpreted. Subsequently, since there was a change in law, so not that judgment was gone. But so far as 218 is concerned, the language is similar. That is my only submission. That since the language is similar,
You cannot escape the law which has been settled in Ghanshyam Das.
yes, no, Ghanshyam Das will not consider as Kolkata Municipal Corporation Act.
So therefore, demolish the illegal construction upon setting aside of this order
in this case,
and recover the amount from the person responsible.
that is the what's the. We don't have any affinity. This order has been passed considering
because there is no escape route, and now the situation is completely different.
that is
The situation which was prevailing in 1970s. You are doing municipal
it has
matters.
become
you are
a menace. So
representing
that is-
Mali municipality
that is that
for long period. You
absolute.
know better than this court
Absolutely.
that what is happening.
Now, my lord, there is not some change in the law so far as KMC Act and my lord, HMC Act is concerned, but there are also no definition of minor or major deviation. There also they have not defined what is minor, what is
What
major.
is the decision of Deepak Mukherjee's judgment?
Deepak
First
Mukherjee-
paragraph.
At that point of time, there was no my lord, law permitting KMC or HMC to my lord, regularize. Subsequently, amendment came after Deepak Mukherjee. Amendment came, but regulation have not been framed. So they cannot.
And not only this, there are separate building rules nowadays.
2007 rules of my lord, West Bengal municipal rules and KMC rules.
Now from 2009, Rule 26 has been come into force.
Right.
I was asking Mr. Mukherjee on another day, which was not there under 1951 Act.
Right.
There are only 2 windows are left open to the person responsible in respect of internal and external deviations. They are required to follow the procedure which has been there under section under rule 26 sub rule 2A and B.
I understand the situation presently is very bad. There are some cases, my lord, where it's a residential house of a my lord, poor man who has my lord, constructed something beyond this action.
Is it the case?
It is not a residential, not a commercial. It's a my lord, G+1.
Maybe residential. Is it the case that a poor man he could not construct?
There is some my lord, observation to that effect. The owner has done
Maybe,
obvious
but that
haja,
will not. This will not be proper for taking into consideration the entire issue.
my only submission would be, you know, there might be may not even this case, but there might be cases where there are not poor persons constructing which needs to be demolished if it is treated as not
In the
shall.
matter of deviation of the plan sanctioned in favor of the person, there is no rich and poor. Even if poor constructs violating the sanction plan, there is no respite to the poor person.
Then may has to be read as shall. What has been done in Ghanshyam,
Yes,
it has to be read. Then it is mandatory. There is no discretion. May has to be read as shall. That is the interpretation.
So where is yours? 1993 Act of
Because 93 Act 218 is similar to my lord, 414, which was prevailing in 51 Act. That is my only submission.
This was the submission so far corporation is concerned. So Kolkata Municipal Corporation.
Corporation.
Similar,
That may, but
perimeter provision is there.
perimeter provision. That is not the only submission. Right.
But that will not help you.
Because
The court of equity, so therefore court has to consider in the present context
facts of the case.
in the present context also.
In this
If
context, my lordship,
municipality is given power to exercise discretion in the present scenario, the result would be disastrous.
Only lordship will not, so far as facts are concerned, page 50 may be considered by your lordship, that's all, page 50 of
There
the-
is section 218 that may has been used.
My lord, kindly comes to me, lord.
Subsection 1.
Subsection 1, if the board of council is satisfied, then not one A, B, C is given, or just after that. It may, after giving the owner of the building a reasonable opportunity of being heard, make an order directing that the demolition be demolished.
They have right to prefer act.
And Purushottam Lalji, the language has been quoted.
Special circumstances. Special circumstances is there. 635 of the Kolkata Municipal Corporation was not there at that point of time.
35 repealed the previous.
Yes.
That is the ground on which
And Purushottam Lalji is in the context of 414
of the previous act.
Yes, that is
51 act.
not there so far your municipality is concerned.
No, but language is similar. 414's language is similar to 200. That is the only submission, my lord. That the language is similar. 218 also uses the word may. That is the only discretion left with the.
That's right. Let me go through the order first.
Well. বারান্দা সেরকম বারান্দা পুরোটা না পুরোটা ছিল না বলে চালাক দেয়
বাড়িয়েছে একটু তারপরে জীবনটা অ্যাভেলেবল তো city to check steps initiating demolition proceeding initiative করেনি তো এটা তো 218 নয় এটা বিপদ কাউন্সিলর ডিসাইড করেছে এটা তো 18 নোটিস আনি না এটা অবজেকশন করে হিয়ারিং করেছে এটা হচ্ছে ফার্স্ট স্টেজটা স্যাটিসফ্যাকশন স্টেজটা হচ্ছে ইনিশিয়েটিভ করেনি বিপদটা ইনিশিয়েট করতে হবে প্রসিডিং এটা ভাঙা কেন ভাঙা হবে না এটা extra Wrong direction again. That's the wrong direction. Wrong direction.
তো পালের ঘরে তো সব ডিসাইড হয়ে গেছে। কোনটা সৌমিক তো পালের ঘরে তো সব বলেই দিয়েছি রেগুলেশন করতে পারবো, ডিসাইড হয়ে গেছে। কোনটা নাম্বার অফ কেস দীপক মুখার্জি
জাজমেন্টটা দেখাচ্ছি
রেগুলারাইজ করতে পারবো বলি জাজমেন্ট এই তো নাম্বার অফ
Khaja has been converted into veranda, and which is a normal deviation.
because of the area, my lord.
What is Khaja, Mr. Banerjee?
Chaja, my lord, some lord, sir.
It is on the window,
Cornish over the window.
so that the rainwater do not disturb the residents of the building.
Chaja has been connected. So it has been
In order to
extended
prevent the rain, and that has been converted into
into a
veranda.
veranda.
And what about the construction of G+1 plan, and the person responsible constructed
No, G plus-
second storied?
No, G+2. This he started to make G+2, which was demolished by him. He demolished the second floor.
But it come to page 49.
Pillars were raised, which was demolished by him. 49, my lord. A, B, C, my lord.
So, second paragraph, another allegations made by the joint complainers
Yes.
that owner of the holding constructed G+2 building through promoter, constructed G+2 building through promoters.
That is the allegation. The finding is not the previous page. Kindly come to the previous page, my lord. No, the same page, my lord. Same paragraph, my lord. The next paragraph.
Yes,
Next
read it.
paragraph, same page. The Board of Councillors, present members carefully gone through the papers and found that the municipal authority sanctioned the proposed building G+1 over the disputed property, which is admissible as per front access. After receiving the objection, carefully inquired into the matter and issued stop construction notice to the owner against such construction. It is fact that the owner of the holding was attempting to construct extra floor upon first floor, which
Was not attempting. The owner of there is no meaning of some of the constructions. It is fact that the owner of the holding
attempted to construct.
Was attempt to construct.
So
What does it mean? I do not.
Language, my lord, there is no
Yes.
meaning, my lord. Attempted to construct the extra floor upon first floor, which was illegal. But after hearing and as per oral direction of the municipal authority, owner of the holding removed the column which was made by him on the first floor roof with an intention to construct the entire floor. After removing the same, owner of the building pressed for withdrawal of the stop construction notice. So that was removed. What remained is, my lord, then A, B, C. C side there is no deviation, but D, east side there is deviation. That is the finding. And Chaja has
How
been
this
converted.
can be retained?
Chaja has
And the Chaja has been converted into veranda.
Chaja has been converted, and I'm not so far as not little projection is also there because permissible is not. I'm reading. Back side open living space are 8 feet 2 inch and 6 feet 6 inch at ground floor. In place of, D, page 50, D, on east side.
Yes, on
East
east side.
side, the back side open living space are 8 feet 2 inch and 6 feet 6 inch at the ground floor in place of 6 feet 7 inch, but 2 feet 6 inch projection at the first floor of the entire that side. So, space is not more. They have left more than not the open space, but then they have projected. That is the violation. Within the side space norms, rules, but there is violation of the plan. If it is 2 feet 6 inch, then it becomes হ্যাঁ 6 feet 7 inch 2 foot 9 inch একটা জায়গায় 8 ফুট 2 ইঞ্চি ওখানে ডিভিয়েশন হচ্ছে না এখানে ডিভিয়েশন হচ্ছে তো there is deviation.
Eight feet 2 inch and 6 feet 6 inches as per the plan.
Ground floor, no, ground floor, actual. That is the actual on the ground floor. But in place of not 6 feet 7 inch. But then Lord, the first floor Lord, they have extended. So it becomes instead of 8 foot 2 inch, it becomes Lord something around Lord.
So in the
6 feet.
first floor, the backside open living space is 6 feet 7 inch. 6 feet
Yes.
7 inch.
6 feet 7 inch. No, that is not the as per plan. 6 feet 7 inch. They have left 8 foot 2 inch and 6 feet 6 inch. That is on the ground floor. But then in the first floor, Milord, they have extended 2 feet 6 inch. That is the extent. That is the
Comes to 6 feet 7 inch and 2 feet 6 inch.
no
The
Milord.
first floor.
First floor it shall be more less. First floor it shall become Milord. No. Ground floor is 8 feet 2 inch and 6 feet 6 inch. If after that, if there's a projection, it becomes not 4 feet instead of in place of 6 feet 6 inch, and in place of 8 feet 2 inch, it shall be not 5 feet 8 inch, 5 feet 7 inch on the first floor, in place of 6 feet 7 inch. So that is a deviation. 8 ফুট 2 এর জায়গায় যদি 2.5 ইঞ্চি বেরিয়ে যায় 6 ফুট 7 ইঞ্চি there is deviation.
So apart from this veranda, the chaja has been converted into veranda. Where are the other deviations?
Other deviation, Milord, on the other side, there is no deviation. Because Lordship will see, Milord, the just previous
Just a minute,
page.
let me get a concluding point.
এখানেও আছে, সাউথেও আছে। এখানে বলছে না, প্রজেকশন বলছে। State side. Something more than I don't know.
Now, where is the power of regularizing
No,
this?
no power. The judgment also doesn't say regularize, power of regularize. The judgment only says, Purushottam Lal only says that
No,
whether.
no, I am asking you,
Fine.
so
We
far
don't
the
have no power is
municipality is concerned, where is the
no power.
statutory power?
Regulation, no power is there. That is not admitted. There is no power to regularize. But whether we shall pass an order of demolition or not,
Are you affected by conversion of sunset, that is Chaja, into Baranda or other deviations?
My point is before you, Lordship, that my last para of the.
Then I will restrict and
One
direct them
follows
to demolish the veranda, and rest of the deviations will be there as it has been. Major deviation as it appears that the Chaja has been converted into veranda.
Well, my point, my submission before you, Lordship, when there is a deviation and stop notice was served, and thereafter, my lord, you do the stop notice. That is why regularize the construction, my lord.
I am asking you
Yes.
that what are the deviations you are complaining of?
Inquiry
Instead of
was,
procedural aspect, what are the main
my point is,
deviations?
my lord, inquiry was done.
What are the main deviations you are complaining
may
of?
humbly submit something. A fresh inspection may be conducted. Your Lordship now. What is the extent?
No,
As on, there might be further construction. We don't know because this is a 2015 order was passed, 14. So 10 years, we don't know what has happened. What is the position as on date?
But second floor have been constructed.
ফার্স্ট ফ্লোরের উপরে ইট করেনি ওটা বাড়িয়েছে ওটা শুধু জায়গা নেই ওটা বাড়িয়ে দিয়েছে
First floor already, my lord, extended the, enclosed the position of the other, my lord. Other,
First floor?
first floor already enclosed. The co-owner and also other premises there, they have enclosed there.
Okay. Encroachment question cannot be decided by us.
ওই ঝাঁঝাটাই বাড়িয়ে নিয়েছে
That is what I am asking you.
He's saying
If that Chaja has been converted into veranda, that also appears from from this order which is under challenge. Then I will direct the municipality to demolish the Chaja so that the construction of that part of the building should conform to the sanction plan.
as Chaja it is permissible, as veranda it is not permissible
Yes.
as per the rules. That is not the position.
Well, on the Jhaja, my lord, they make a construction.
Yes, that is there. They have converted it into veranda. That is at the east side of the
East side.
of the building, of G+1 building. Then I will direct the authority to demolish the Chaja, that veranda, and keep that part of the building as Chaja, which shall conform to the plan sanctioned by the authority.
বারান্দা বলে কিছু নেই সবটাই বাড়ি
But there is no baranda that instructed my client.
Chaja has been converted into veranda as it appears. Come to page 50. Please read on the east side, that is back side, open space, open living space are 8 feet 2 inch and 2 inch and 6 feet 6 inch at the ground floor in place of 6 feet 7 inch and 2 feet 6 inch projection as first floor entire that side. Now from the above it is clear that the ground floor side space is most of the side are okay. Moreover, the owner left extra land as side space at the north, south, and east side that require space as per rule, and most of the projection made by the owner at first floor within the area of the extra space of land. As a result, side space of the ground floor and first floor averagely most of all okay except east side. Though the said projection made by the owner by deviation the sanction plan not the same are within the limits of building rules. Only at the east side projection is made by the owner not according to the rule. Although projection for Chaja within the limit of rule is admissible, and in this case projection of said side is something more than admissible, or as Chaja converted the same as veranda, which may be considered as nominal deviation. So therefore, the major deviation today, the building is not a two-storied building. Building is G+1.
G+1.
And only that major deviation as it appears, this chaja has been converted into veranda.
My lord, as instructed my client, my lord, there is no baranda. On the baranda, they make it constructed.
That is not something new which comes to you.
Because
Because report,
client is
whatever is on
present, my
record,
lord, he is instructing me. And my
because
submission.
2014 inspection was made. That is a
Then make an inspection and come back. Make an inspection and come back.
My respectful submission
Why is
before
that?
your lordship. Your Honorable
That is
Justice,
violation of law.
Sumitopal, a number of cases has been disposed of. Your lordship knows very well. But there, my lord, only, my lord, what, my lord, pass the order, observation. You cannot regularize any, as there is any deviation. This is judgment, my lord, but
You keep it with you.
your lordship have experience, your lordship
Yes.
knows that. I am not.
In line with Ghanshyam Das, possibly, my lord, something.
The number of cases, my lord, already decided.
And the private respondent is not being represented.
No, my lord, they
have
tried
been
to
served.
serve. No, my
They
lord.
have served. Last
They
occasion.
tried to serve, it has left or something has come back. On the last occasion, my
Where
lord,
location I send
door
you.
locked. So that is also one, my lord, difficulty so far as inspection, because if the door is locked, we have to, my lord, do it from outside.
My submission respectfully is
Yes, sir.
submission.
Let me
To pass the order of demolition, they make a
writ petition. In the writ petition,
appeal before the
the
appropriate
order dated
authority.
31st January 2014 is under challenge. Is under challenge, whereby Board of Councillors
Interpretation of May has maintained that May in 1980. So this May in 1980 will also have that discretion.
My lord, only one submission, my lord. I am just not being entitled in this matter, my lord. Just another judgment of Honorable Justice Rajshekhar Mantha, which has not held. I've just got the judgment, which says that since May was there in the 51 Act, which was interpreted by the 3 judges bench, then, my lord, knowing that, my lord, the legislature has again incorporated the word May in the subsequent Act. So the interpretation of the subsequent May shall be, my lord, contrary to what has been interpreted in Ghanshyam Das. It should be, my lord, again May discretion, not shall.
in view of section 635, that point does not lie. Sorry.
635 only repeals the previous act. But the
Yes,
same
and
language.
in Purushottam Lalji, the situation was considered. And now much water has flown
No,
to
that-
river Ganges. I will not permit. It is a court of equity. Sorry.
Fine.
And the building rules have also been changed.
The rules are subservient to the
Yes,
statute.
yes.
So
These are also required to be considered in the light of the plenary legislation.
Well.
হ্যাঁ কি বলছিলাম? না, whereby বাকিটা কেটে দাও. The concerned authority of Pali municipality passed an order based on the report of Municipal Engineering Directorate in connection with the construction made by private respondent number 7 at (29) 23/9, Hajrapara Lane, Bali, Howrah. Stop. On peruse, stop. The learned advocate representing the petitioners submit submits that the grievance of the petitioners are twofold, comma, one is construction of drain, one is renovation of common passage and construction of drain, which ultimately converted the same which impacts the right of other occupants of the adjoining buildings on the said common passage. And as well as normal flow of sewage through the said drain. And the second complaint centers around construction of G+2 storied building by the respondent number 7 at the aforesaid holding number on obtaining sanctioned plan for constructing G+1 storied building. Stop. There are other deviations according to the petitioners while making construction, including converting a chhaja at the east side of the building, at the east side, first floor of the building, second floor of the building, no, first floor of the east side, first floor of the building into veranda. Stop. According to the petitioners, deviations made by the respondent number 7 being person responsible are required to be demolished. Since the order of regularization made by the concerned authority of Bali municipality, video order dated 31st January 2014, is without jurisdiction, since the Bali municipality has got no statutory authority to regularize deviations on receipt of fees. Stop. Next paragraph. Now, in support of such contention made on behalf of the petitioners, reliance has been placed on the judgment of Apex Court On the judgment of a coordinate bench, reported in 2014 4 Calcutta Law Times, 1 within bracket HC, within bracket Ghanshyam Das versus Kolkata Municipal Corporation and others. In order to demonstrate before this court that the concerned authority of the municipality in the context of Section 218 of the West Bengal Municipal Act, 1993, within bracket hereinafter referred to as the said Act of 1993, close bracket, said Act of 1993, quote unquote, is not authorized to regularize unauthorized construction. Syntax table form. Stop. The next paragraph. Per contra, Mr. Banerjee, learned advocate representing Bali municipality, has strenuously argued to defend the decision is contained in the impugned regularization order dated 31st January 2014, and it has been submitted that though initially attempt was made by the respondent number 7 to construct second floor upon constructing columns, RCC columns, but subsequently on the intervention of the municipality, the said columns were demolished, and at present the building in question is G+1 storied building, for which sanction plan was accorded by the municipality. However, it has been submitted on behalf of the municipality that there are certain minor deviations at the different parts of the premises in question, out of which the striking one is conversion of chaja into veranda at the first floor of the said premises, which the eastern side at the eastern side of the which is not permissible in terms of the sanction plan. Stop. Next paragraph. In addition thereto, on behalf of the municipality, reliance has been placed on the judgment. Reliance has been placed on 3-judge bench judgment of the Apex Court, reported in AIR 1972 Calcutta 459 within bracket FB close bracket, within bracket Purushottam Lalji versus Ratan Lal Agarwala close bracket. In order to contend that in the context of section 414 of the Calcutta Municipal Act, 1951, the Apex Court interpreted the power conferred upon the municipal commissioner, MC capital দেবে, the power conferred upon municipal commissioner whether to regularize deviations or not in consideration of the building rules which are relaxable or not, which are relaxable or not relaxable. Stop. According to the municipality, since in the context of section 414 of Calcutta Municipal Act 1951, power of municipal commissioner was interpreted by the apex court, wherein it was decided that the apex court, wherein it has been decided that in a particular, wherein it has been decided in particular circumstances, the municipal commissioner is authorized to exercise discretion not to pass order of demolition. The said principle laid down by the apex court may be applied in the present case in the context of section 218 of the said Act of 1993. For
May I take a lordship, that matter has been called up.
regularizing the minor deviations as delineated in the impugned order dated 31st January 2014. Next paragraph. Having considered the submissions made on behalf of the parties,
বারণটা উইথ কভার্ড মাই লর্ড।
next paragraph. Having considered the criteria. It is already recorded in the previous order dated 22nd January 2024 that private respondent number 7 was served was attempted to be served with a notice, but the envelope returned with an endorsement that addressee left, quote unquote. Addressee left, quote unquote. Therefore, the court decided to hear the matter finally. Stop. Today also, respondent number 7 is not represented, and therefore matter is being considered in absence of the private respondent. Number 7. Stop. Next paragraph. However, this court has considered the submissions made on behalf of the petitioners and Bali municipality and perused the impugned order dated 31st January 2014. Stop. On perusal on perusal of the said impugned order, it appears that apart from other deviations made by the Respondent number 7, while making construction after obtaining sanction plan to erect a building, to erect G plus one storied building Chaja at the first at first floor east and at the eastern side of the said premises has been converted into veranda, which is not permissible in consideration of the plan sanctioned by the municipality. Question arises for consideration before this court whether the concerned authority of municipality is authorized to regularize deviations made by the respondent number 7 on acceptance of fees, as it has been decided in the order dated 31st January 2014. Stop. It has already been submitted by the learned advocate representing the municipality that West Bengal Municipal Act 1993 does not contain any provision which empowers the concerned authority of municipality to regularize deviations in making constructions dehors the sanction plan on acceptance of fees. Stop. In spite of absence of any provisions empowering the municipality to regularize deviations, in the present case, regularization of deviation has been done upon imposing rupees 1,000 as fee on respondent number 7. Stop. Though attempt has been made on behalf of the municipality to decide the issue otherwise and not in sync, SYNC, with the decision as contained, as contained, and not in sync with the decision of the coordinate bench in Ghanasham Das Supra, in view of in consideration of the law laid down in Purushottam Lalji Supra, since on similar statutory provisions contained in section 414 of Calcutta Municipal Act 1951, three-judge bench of the Supreme Court decided that the municipal commissioner is authorized to exercise discretion in view of use of words in section 414. Stop. While taking note of such submission made on behalf of the municipality, it needs to be kept in mind that that the validity of the regularization order dated 31st January 2014 is being considered in the context of different statutory provisions, which is section 218 of the West Bengal of the said Act of 1993. Stop. Question further appears when provisions are perimetered here, whether the interpretation attributed by the apex court in Purushottam Lalji Supra is applicable in the present case or not. In this regard, this court finds it apt to rely upon Ghanshyam Das Supra, stop. The coordinate bench in Ghanshyam Das Supra also took note of the decision of Purushottam Lalji Supra and found the same is inapplicable in view of the fact that the municipal commissioner was divested of the power which the commissioner had previously under the old act. In consideration of section 635 of the Kolkata Municipal Corporation Act 1980. Stop. In addition thereto, the interpretation attributed by the apex court in Purushottam Lalji Supra was in consideration of the special facts and circumstances as described in paragraph 7 in the said judgment. Stop. It was recorded in paragraph 7 of Purushottam Lalji Supra that according to the superintendent within bracket building B capital S capital superintendent, comma, there was no serious infringement or violation of any building rule, comma, nor was there any obstruction of light or air into the adjoining premises. It was found by the apex court that there was slight infraction of the relevant rules. Stop. Situation is completely different so far the case which is at my hand today, where a chaja has been converted into veranda, which cannot be termed as a minor deviation, especially when the residents of the adjoining house are raising objections. Stop. At the same time, this court cannot now at the next paragraph. At the same time, this court finds it appropriate to quote below paragraph 22 of Ghanashyam Das Supra. Paragraph 22 টাকে সেট আউট করে দেবে। Next paragraph, this court finds it together. It appears that in the present fact situation, the principle embodied in Ghanashyam Das Supra is squarely applicable. In view of the fact that there is no power conferred upon the concerned authority of the Bali municipality to regularize deviations which have been made divorce the sanction plan. Stop. Next paragraph. In addition thereto, the present scenario needs to be taken into consideration while interpreting the statutory provisions as contained in section 218 of the said Act of 1993 in view of mushrooming of unauthorized construction by the residents of the municipalities and corporations, as it has been noticed by this court regularly while dealing with corporation/municipality matters. This court is a court of equity. Stop. If an interpretation is attributed while defining the authority of municipal authorities in the context of section 218 of the said Act of 1993, which grants power to the municipal authority to regularize unauthorized constructions/deviations, that may lead to a menace. Stop. Next paragraph. Accordingly, now next paragraph. In above conspectus, the order dated 31st January 2014, passed by the concerned authority of Bali municipality, stands set aside. Stop. The concerned authority of Bali municipality is directed to demolish unauthorized constructions which are dehors the sanction plan accorded in favor of the person responsible. So far, the building in question is concerned within a period of 6 weeks from the date of communication of this order, and the cost of such demolition is to be recovered from the person responsible. Next paragraph, with the aforesaid directions, with the aforesaid directions and observations, the writ petition stands disposed of. There shall be no orders to post. Urgent xerox ধরে ঘোরো আস্তে আস্তে সিমিলার একটা ম্যাটার এরাও নিয়েছে, ডিটেকশন দিয়েছিল বাড়িতে অরিজিনাল সাইডে। তুমি একটু অন্যের সঙ্গে কথা বলে নিতে পারো, কোনো অসুবিধা। ওটা অনেক বড় ইস্যু, তাও কিছু কিছু ইস্যু সেন্ড। শোনো, এটা নাও, এইটা দুটো জাজমেন্ট। হ্যাঁ, এটা খুলে আমার বাকিটা দিয়ে দাও। এই জাজমেন্ট এখান থেকে খুলে নাও, বাদ বাকিটা আমার লাগবে। কোনটা রেসপন্ডেন্ট গুলো আছে এটার কপি নিজের কাছে কেএমসি কাছে পাবে, ডিপেন্ড বললেই দিয়ে দেবে। তুমি এটা নিয়ে দাও, তাহলে 1 2 3 কে আমরা ডিলিট করে দেব। নেক্সট
But this is that matter where the question arose, my lord, whether the corporation and the municipalities can be arrayed as respondents in the same writ petition. But we have taken instructions, my lord, pursuant to your lordship's last order. My instruction is that the corporation respondents 1 2 3 that may be deleted from the records of this writ petition, and this writ petition may be proceeded against the municipalities only.
1 2 3 জন্য আলাদা প্রেস liberty to file,
and liberty may be given to proceed against the corporation separately on the self same cause of action.
So therefore, you want to array chairman Bhattapara municipality, chairman Konnagar municipality, chairman Noyati municipality.
Right.
But my submission is that
That can be done because these municipalities are under the same statute, under the same statute. So therefore, only these municipalities are required to be represented. You are representing which municipality?
Bhattapara municipality.
Very
But
good.
as per section 13(2), my lord, the municipality may be shoot and may shoot in the name of the municipality,
But
not the chairman.
only give me leave to add, my lord,
But this petition is not.
kindly done.
তো এখানে correct the cost.
To correct the cause title, my lord.
That's why maintainability has been kept open.
Aye.
Admitting the writ petition. এসো expand. You are relieved.
The affidavit has been filed, my lord, in this proceeding.
But then, my lord, the prayer should be amended, my lord. But the annexure, prayer, all the things are club of, my lord.
No, this is not proper. My lord. The
But they,
number
some portion is the Calcutta Municipal Corporation, some portion is the club. One record is the name of the Bhattapara municipality,
I am
one is the Noyati municipality. And another thing is that the valuation board is not a party. Valuation board impose the valuation. Municipality hands is very tight.
we are not challenging.
I am not added the valuation board as a party respondent, my lord.
Valuation board need not be a party respondent.
They are challenging the imposition of enhanced tax, my lord. Valuation
board তোমার সই করা চিঠি আবার
is not, the valuation is not made by the board of councillors. It's a valuation board.
But Mr. Ghosh, there is no separate power, separate prayer couched against the corporation.
no,
There is no
AMC.
separate prayer couched against the corporation in the writ petition. There is no separate power, separate prayer made. Only the valuation is an issue. That is that due to installation, whether the valuation can be enhanced or not. Now, the court asked the learned advocate representing the petitioner's last occasion, you were also there, that whether how the writ petition is maintainable against the corporation as well as municipality when these authorities are guided by two different statutes. Now, today they are submitting that they don't want to proceed with the corporation by presenting this writ petition. So, therefore, the names of the authorities under the corporation may be expunged and let the writ petition be heard. So far, other respondents are concerned.
It is up to them. If we are relieved, then we have nothing to say. Online submitting by affidavit opposition here, my lord.
That has been kept with the record previously.
That has been kept with the record. And my lord, the one thing, my lord, I may submit, my lord, that issue, my lord, which they have, my lord, brought in this proceeding, that has been decided by this court, and the matter is now pending before the division bench. The appeal is also appearing in the list today.
That is on merit. That is insofar as the corporation's demand and stand is concerned. Against the municipality, if the municipality
is also there.
We are not there. We are not there. We are not. We have not fighting.
If they want to rely upon the same judgment, they will at the time of hearing of the writ petition.
Chennai himself is a party there.
Yes, I know that.
Corporation
because there has been
municipality
decided against the municipality.
To what the on the issue is this regarding the imposition of the valuation and imposition of tax.
But my submission is total, valuation is a valuation board, my lord. It's not
whether the tower will come within the definition of premises so that the annual valuation can be charged on the basis of the rental value of the towers. This will be the broader question. So for that, municipality has raised a bill or demand on the basis of the rental value of the towers.
So why, Mr. Sen, you are praying for expunging the name of corporation instead of municipality? Since the municipality corporation has filed an affidavit in this matter, let the issue be heard against the corporation first.
But I'll tell you, Lordship, why.
Why? Because the issue is same. Only thing is this, when there are two authorities and these two authorities are guided by two different statutes. So therefore, in a single writ petition, the issue against the two different authorities may not be decided and court may find it difficult. Since the corporation has filed an affidavit in opposition, let the corporation and let this matter be, let the issue which has been raised in this writ petition be decided in consideration of the submissions or arguments of the petitioners as well as corporation. So, but municipality is concerned, they have not filed any affidavit. So, therefore, you file a separate writ petition against the municipality. Otherwise, it is a hearing bench, it will create difficulty.
Actually, my instructions are that
I understand, but the court will be in difficulty.
Why? May I just try to assist your Lordship?
Because two other corporation municipalities are not being represented.
No, I am saying that.
And only this Bhattacharya municipality, Bhattacharya municipality,
I am also, sir.
They have not filed any affidavit. But if corporation has filed their affidavits and they have presented their case, so therefore at this stage, if the corporation is eliminated, then there will be a difficulty in deciding the issue.
In my contention, my lord, my contention is the municipality is not the party.
So far, corporation is concerned, your writ petition is complete. So far, the municipalities are concerned, you have not added municipality as party respondent.
I'll tell you.
So therefore, on this score, it would be better you may take another instructions. It would be better and it would be beneficial. So far, this court is concerned, if the corporation is represented, since corporation is not taking this point of absence of necessary party, which the municipality is taking. Today, because the municipality is not the chairman of the municipality's party, municipality is not a party. They have not filed their affidavit. But the corporation has already filed their affidavit. So the issue ought to be decided in presence of the corporation.
Yeah, may I say this? Difficulty which we'll face is that, as my learned friend submitted, there is a division bench, matter is pending before the division bench in relation to the stand corporation has taken. That is more or less decided by one bench, issue before the division bench. So what if it is restricted only to corporation today, and I cannot proceed in the arguments which I had made before the another single bench.
But the decision of the division bench will definitely govern this issue,
So
which is before this court.
But division bench is now
The corporation party
appeal is not being taken up now.
না না আছে লিস্টে আছে
লিস্টে আছে
লিস্টে আছে
Then the matter has to await the decision of the division bench.
That can be done. If similar, same issue, Mr. Mukherjee, same issue, you are appearing there.
No, I am not appearing. I am not appearing.
Chennai is the party there.
No, it is the same issue, but that is what I am saying. Municipality against
Chennai is
municipality,
also-
there is no judgment.
The case of Chennai is there.
municipality কে আমি চ্যালেঞ্জই করিনি and there is no writ, there was no appeal.
Yeah, also the similar applications have been taken out by Mr. Upadhyay in some other matters before this court. And I have allowed the learned advocate representing the petitioner to amend the cost title.
Today also it is there in the.
In that event, let the matter go out of list for some time. Since the matter touching upon the same issue, similar issue, the same issue is pending before the division bench.
না না সেম ইস্যু বলবেন না same
No, because kindly not says, but absolute same issue because against municipality there is nothing
we
there.
have not filed any.
We have not filed any challenged anything. Lordship,
Issue. At the time the matter is heard, matter is heard in presence of the learned advocates representing the petitioners and Kolkata Municipal Corporation as well as three other municipal as well as Bhattacharya municipality. Stop. Next paragraph. Mr. Mukha, it has been submitted on behalf of KMC that similar issue is pending before the honorable division bench in connection with two intra-court appeals. Stop. Matters. It is also submitted that it is also submitted that those two matters are running in the list before the honorable division bench.
There are four.
It is also submitted that those matters are running before the honorable division bench. Two matters na kore, those matters are running before the honorable division bench. Stop. Next paragraph. In view of pendency of the issue before the honorable division bench, let the matter go out of list with liberty to mention after disposal of the appeals.
Regarding the maintainability, my lord, open.
Today I am not saying anything. হ্যাঁ ওটা দিয়ে দাও
রোজগার হচ্ছে অসুবিধা কি
লাস্ট অর্ডার যে এফিডেভিট সার্ভিস করতে বলেছিল যে সাবস্টিটিউট আগে করলাম প্রমিতা মুখার্জি।
Item number 6.
But I'm the petitioner, my lord. But on the last occasion, respondent was substituted. Affidavit of service may be taken on record. I've served the added respondent, the substituted respondent record. As per the last order, my lord, we have done the needful. The impugned order is at page 61.
Just a minute.
Draft a copy.
You are for the
I'm for
corporation.
corporation. Well, they have challenged the order of the demolition. Well, there is the appeal lies against that order. But they have not preferred that appeal, but come before it.
My lord,
At this stage, after a lapse of so many days,
No.
what is the position at present?
No,
I have to
may I?
take inspection and give a report before your
No. The appeal does not lie. This order is without jurisdiction. Appeal lies only if a special officer of the officer had regularized the structure after the amendment. This is pre-amendment. Pre-amendment never had jurisdiction, so an appeal could not have lied. My lord will kindly come to page 61. I'm covered by on the division.
The direction for affidavits.
The affidavits have been completed. Affidavits filed. Alternative remedy would have lied if a authority exercises jurisdiction, and if I say that it was wrongly passed, but if that authority never had jurisdiction at all, then would an appeal lie? That is a question which has to be decided by my lord.
order has been passed under section 400.
400.
Subsection 1.
At that point of the order passed on
Which page?
61. Page 61. Order dated
Application, which petition? Just a minute. Why so many applications?
One was for substitution, my lord. That was allowed. The applications are no more there, my lord. These are
Application for injunction is there.
I am pressing on the main rate petition only. I'm pressing on the main rate petition. It can be disposed of here and now. Since the affidavits are complete in the rate petition.
ও আচ্ছা, রিট পিটিশনটাই পাচ্ছি না। মানে রিট পিটিশনটা আগে করে দেবে, মানে আমরা অসুবিধা হয়। যদি হয় এটাও ক্যান। ক্যান আবার রিট পিটিশন, এরকম সঙ্গে ক্যানটা বাঁধা আছে কেন বলো তো? ক্যান দাঁড়াও, তোমরা তো বস্তার মতো ফাইল তুলে দাও। এটা মনে হচ্ছে ঠিক আছে।
এটা তো আমরা এখন নতুন ইন্সপেকশন না করে ওই রিপোর্ট দিলে কি করে হবে যদি আসতে হবে আমাদের কাছে, আমি তো আর ঘুরতে যাইনি। আমি সেই রিপোর্টটা ভেঙে দিয়েছি। মানে আপনার মক্কেল ভেঙে আপনি মানে টিএমসি কি করে ভাঙবে? What is the difference on the ground of jurisdiction? Responding to
Old building, construction. Intention against the demolition of that. আচ্ছা আচ্ছা। Roof was there. Roof was changed and RCC construction has been made.
My lord, the
So
position,
old building of Bagbajar.
but
there you
this has
know
already
that-
been demolished.
that,
Already been
wooden-
demolished.
Wooden frame is there where this is being done.
But because they are,
Therefore, that has been changed and a RCC construction has been made. Otherwise, termite problem and other problems are there.
my lord, one kind indulgence, just this
You
construction.
stay at the not Kolkata, you will find the difficulty of old building.
That is there.
Only the roof, which might be a Koriborga roof, that has been changed and RCC construction has been. No new construction. No extension of construction.
Extension is there, my lord, but that has already been demolished. Demolished even by the private
That has been
respondents.
demolished.
It has already been demolished. But
Prefer an app.
if this order remains, my lord, they can construct once again. That is the only reason
Then
this.
prefer an appeal.
My lord, will kindly consider that this my lord, this
Because
order.
under section 400 subsection 5 there is a provision. Hey, that was Kolkata Municipal Court.
403.
My lord will kindly consider one thing, my lord. Under section 401, this could have been done today. But as on that date, there was no jurisdiction.
In old Calcutta, you will find that there is no space in between the load-bearing walls.
That is there, but
where you will go?
That is there. In this, my lord, this is not load-bearing walls, my lord.
The nature of construction. Person responsible peers made unauthorized constructions of unauthorized construction, that is reconstruction of the roof at the first floor level. Veranda, reconstruction of first floor level veranda by RCC at the southern side and construction of RCC roofed masonry structure at the first and second floor of the southern side. Therefore, a mortar roof was there. That was changed and a construction, no new roof. A old roof was there that has been substituted by concrete roof.
My lord will kindly appreciate one thing, that this, today it might have been done, but as on that date, this was passed on 30th January.
You taste the legality of this order by preferring an appeal.
My lord will kindly appreciate that this has been pending for quite some time, and at this, my lord will kindly appreciate that.
Dismiss for default.
You dismiss for default, that
Yes.
is there, but my lord
Was
will.
dismissed for default.
Yes,
This court has restored it.
No, no, that is there,
Yes,
that is
yes.
there. I cannot.
Don't open your mouth too wide, Mr. Counsel.
But that
Yes,
is there,
yes.
that is there, that of course, the only thing, my lord, my lord knows that there is an appeal, there's a provision for appeal if there is an order passed under section 400. But this order is not under section 400 because as on that date, section 400 did not empower him to
400.
to 400.
This 400 proceedings.
400 what?
Discretion has been exercised by the municipal commissioner.
It could not have been done. I have
Yes, that's why you are not satisfied with the order. You
this
prefer an
could not
appeal.
have been passed under section 400. For once, my lord will kindly take up a judgment of a division bench of this honorable court. For once, my lord, for my
Keep
side.
it for higher forum. You keep this for higher forum.
My lord will kindly appreciate that if an order cannot be passed under section 400 as on this day, today it could have been passed.
Deciding the issue. Let the appellate authority decide the issue. Why you have not preferred an appeal? There is an appeal provision.
But as on that date, my case is that
your contention is this. This is not an order. This order should not be treated as an order under section 400.
My lord.
Why not? Because under section 400, commissioner has passed an order upon exercising discretion. Come to section 400.
My lord, even
come to section 400 first.
My lord, I am coming to 400.
Read it.
My lord.
Subsection 1.
Subsection 1, where the erection of any building or the execution of any work has been commenced or is being carried on or has been completed without or contrary to sanction referred to in section 396 or in contravention of any of the provisions of the act or rules and the regulations made thereunder, the municipal commissioner may, in addition to any other action that may be taken.
Municipal commissioner may.
My lord.
So he may pass an order regularizing the construction, or he may pass an order of demolition.
That has been denuded by this.
I will not go into in view of the provisions, since I am not saying that it has been rightly exercised or wrongly exercised. The discretion has been exercised. Since the point you are urging before this court that this is not an order under section 400, so therefore appeal does not lie. This is a wrong submission. Why? Because the commissioner has exercised discretion, or the delegate of the commissioner has exercised discretion that may not be in accordance with law, but for which protection is there under subsection 3. Come to subsection 3 under section 400.
Any person aggrieved by an order of the municipal commissioner made under subsection 1. But I have to admit that it has been made under subsection 1 to prefer an appeal.
It has been made under subsection 1 by use of the by exercise of discretion.
If my lord, for my satisfaction, one judgment, may I rely on just one judgment?
You rely before the appellate court, not at this stage, because the appellate forum is there.
That is there for my satisfaction. I'll just rely on. I'll just take 2 minutes of your lordship's time, not much, my lord. Thereafter, if my lord, I'm not being able to satisfy, my lord.
Sure.
But for 2 minutes, I'll take just 2 minutes of your lordship's time.
The writ petition is filed inter alia challenging the order of.
The structure has already been broken, my lord. That is the only thing I was. Already been broken. The structure is no more even there. Today it does not even exist.
What remains in that? Nothing.
Why this writ petition was filed after 6 years?
6
What
years.
was the delay?
6 years. No, may I? But this was in the original site. Later it was
When the
renumbered.
writ petition was originally filed? Which
2009. It was WP 198 of 2009.
Where from I will get it?
May I just rely on an order? May I just,
16th.
may I just rely on
This is
an
WP number 198 of 2009. It has been converted into affidavit.
Mine.
Right?
It may have been wrongly filed. Must have been wrongly filed. Probably the respondents were outside. I go at that point of time I was not there, my lord.
Not within the jurisdiction, but.
So therefore, I will direct the appellate authority to take decision without taking the point of limitation, since the order was passed in 2009 and writ petition was also filed in 2009. Yes. The writ petition কি বলছিলাম? Inter alia challenging order dated January 2009, passed by the Special Officer Building, within bracket building, whereby person responsible, within bracket PR, was permitted to retain the unauthorized construction made at the building in question. Where is the holding number of the building where unauthorized construction has
kindly hold.
been alleged to is alleged to have been made?
18B Pashupati Bose Lane, Kolkata 7,03,000.
In the order, it has not been stated.
Yes, my lord, in the top of the first page, premises number.
কি বলছিলাম? না made at কি বললাম আরেকবার সেন্টেন্সটা পড়ো। unauthorized construction made at 18B, বাকিটা কেটে দাও, 18B, পশুপতি বোস লেন, ওয়ার্ড নাম্বার 7, Boru 1, under the jurisdiction of Kolkata Municipal Corporation. Stop. The learned advocate representing the petitioner while questioning the order dated 30th January 2009 has submitted that such order or has submitted the said impugned order is without jurisdiction, since the concerned authority of Kolkata Municipal Corporation was not authorized to regularize unauthorized construction. And the concerned authority of KMC directed, illegally directed the person responsible to pay charges for raising unauthorized construction. Next paragraph. Person responsible is not represented today, or respond number 10. Respondent number 10, the substituted respondent number 10. Substituted respondent number 10 is not represented today, but Kolkata Municipal Corporation is represented. Stop. It has been submitted on behalf of, next paragraph, it has been submitted on behalf of KMC that the order ordered that the impugned order dated 30th January 2009 passed by the special officer within bracket building close bracket is an appellable order is an order under section 400 of the Kolkata Municipal Corporation Act 1980. Therefore, the same is an appellable order under section 400 within bracket 3. Stop. Next paragraph. Having considered the submissions made on behalf of the parties and on perusal of the impugned order dated 30th January 2009 and taking note of the provisions as contained under section 400 within bracket 3 of the Kolkata Municipal Corporation Act 1980, it appears that the order in question is an appellable order for which, against which the writ petitioners are required to approach the appellate forum. Stop. Next paragraph. In view of availability of alternative efficacious speedy remedy, the present writ petition is disposed of, thereby granting leave to the petitioners to file appeal before the appellate authority under section 400 within bracket 3 of the Kolkata Municipal Corporation Act 1980 within fortnight from date. Stop. If the appeal is preferred within the period of fortnight against the order dated 30th January 2009, then the Municipal Building Tribunal shall decide the appeal reasonably, but not later than 4 months from the date of instituting the appeal. Stop. However, it's not clear if the appeal is preferred within the aforesaid time. If the appeal is preferred within fortnight from date, point of limitation shall not be a relevant consideration in deciding the appeal, and the appeal needs to be decided on merit. Stop. Next paragraph. With the aforesaid direction, the writ petition stands disposed of. Now, there shall be no orders to cost urgent xerox certificate copy.
One kind indulgence, there's an interim order subsisting in the writ petition. If it can continue for a fortnight,
Why? What for?
This was
What interim order?
The impugned order was stayed. The impugned order was stayed.
Today, if you prefer an appeal, nothing remains.
That is there, but if I take 1 or 2 days.
Sorry, the interim order passed earlier stands vacated. Stop. Applications, comma, if pending, comma, also stands disposed of. Also stand disposed.
Will kindly record that this will not influence the learned municipal building tribunal.
একটা জিনিস ওখানে করে দাও তো। interim order passed earlier stands vacated বললাম তো, তারপরে add করো। However, status quo with regard to the construction at premises number
18B Pashupati Bose Lane, Kolkata.
At premises number 18B, Pashupati Bose Lane shall be maintained by the parties till 3 weeks from date, and if appeal is preferred within fortnight from date by the petitioners herein, the status quo shall continue till disposal of the appeal by the Municipal Building Tribunal. Next,
Item number 7 in this matter, I have challenged the order for revocation of sanctioned building plan under section 397 on the ground of material misuse of facts. In course of hearing, your lordship has direct me to produce a letter or application under section 393. I could not produce. I made an application. Last time, your lordship was pleased to direct my learned friend to produce that application. The copy didn't have it. আপনারা করতে দিন তাহলে ইচ্ছা আছে।
তো করবেই, অ্যাপ্লিকেশন না করলে তোমার স্যাংশন দেবে কি?
হ্যাঁ, ঠিক আছে।
করেছো, মালিক
সে-
আছে কি কথা লিখবে?
হ্যাঁ, মালিকটা বলছি। যে লিখেছিল আগে খুব সুন্দর।
What is the relevant part, Mr. Ghosh?
The relevant part, Manoj, that this is their application. Manoj, the main thing is, Manoj, regarding the ownership. Eventually come to the
Name of the owner.
last but one page.
Serial number?
Serial number 21. Proof of ownership, the family deed of conveyance.
Yes.
And then, Manoj, ABC, they submitted deed plan, register, boundary declaration, assessment report. These are the things. Now, the question came, Manoj, that ultimately that land does not belong to them.
This is the
Presentation.
No, I'll prove.
No.
But this is not their land. I'll show it to your lordship. I'll place it.
How much cost is to be imposed for misrepresenting before the corporation?
If I show that this is a misrepresentation,
What you will show? This is your application?
Yeah, I'm the owner of the land. I show it, but I'm the owner of land. You kindly allow me to, your lordship, kindly show this is they can't not show any document. I show the order.
Whether the client is present in
No, there's no question of client, madam.
Then
I'll place
why
it.
you are raising voice in this
No,
fashion?
sorry, sorry, man, sorry.
That will not cut any eyes.
No, I know it,
Mr.
madam. I know it, madam. Your lordship doesn't say this. Your lordship knows me. Sorry, man. I don't really some problem. Today in the morning I've come only for this.
That will not cut any
No.
eyes. If
Not
you
cut.
go
This is
on
not
raising your voice.
They were also cutting your eyes, madam. Sorry, madam.
I know how to rein in this kind of attitude before this court.
I know your lordship.
Yes.
But kindly excuse me. I apologize, madam. I don't raise the voice, madam. Your lordship knows this. I place the case, madam.
I thought your client is in court. That's why you are trying
this is not the consequence.
make a gallery show.
Madam, then your lordship can he leave the court, madam. You also know that I never showing the gallery show. I always trying to make the case below. Also, I never, your lordship can you allow me? I just place it.
Just a minute. Let me go through the order, which is at page 83. Yes.
No, first I apologize, but sorry, I, but now you're saying why this order is vitiated by material irregularities. Sorry, we also non-application of mine and based on erroneous evidence. I'll show. But before that, I just place my I'm thankful to my friend. You also can see my first deed. I show the deed, then you also can come to page 57. It starts on page 58. In 1994, this company purchased this property from one Sheikh Khurshid Alam, son of late Wahed Ali. Yes, but you also can see the at page 62 the schedule it is given. This is the premises number 32 of the 1B, formerly portion of 34 Kakurgachi main road, not Kakuji main road. As you can see at page 62. Schedule is given. And this is Kakuji main road and with the structure containing an area of 6 shutters, including tenant occupiers fully covered. So we purchased the property from Khurshid Alam in registered deed. The plot is 32 1B and is it occupied by the tenant, covered the tenant. Yes, but so there's slums, we have evicted. But now you also can come to page 73. My lord, corporation when they applied, corporation given the mutation certificate in your favor. 32 of the 1B Kakuji, they have given the SSC number. And they said, with reference to application subject, you are hereby informed that the PR of mutation has been granted in your favor by this department 16 February 1999 and henceforth will be treated as owners liable to pay tax in respect of premises in question or as well as Mallika International Partner. So this is one mutation certificate given by the corporation in our favor in 1999 and we are paying the tax. Now, both the documents I produced, and you see, there's a related documents. This is at page 68. This is an information slip for mutation fees. But here, my lord, we have they say the name of the previous recorded owner is Sheikh Shahjahan joined and Khurshid Alam. So, my lord, we got the mutation slip from the corporation. They say it was recorded earlier in the name of Khurshid Alam, our vendor. So, this is the two documents with me. There's one is sale deed, one is mutation certificate.
Whether the mutation confers any right
No.
upon the owner of a building.
No, it's a settled normal
possession.
It's not title. It's only position.
It's only for the payment of tax.
Yes, I just so this document that will not this is also title. So on sale deed we have. So there's a SSC number in my favor on the corporation, which corporation required. And thirdly, we are paying the tax. And I saw the slip that it was earlier recorded in the name of my vendor. This is my three documents. We applied by this for sanction of the building plan. Then you also kindly come to page 74. This is 1st August 2012. Our LB, my architect at page 74, my lord.
Yes.
This is Jointona, this is my architect or LBS, my lord. This is a letter of the KIT. Reply to your letter, I have to inform you that site plan submitted with your application being examined with trust records. According to the above mentioned property is KIT acquired land in scheme number 7M 77. He said, in 1st August 2012, the chief engineer said it's a KIT land to our architect before sanction of the building plan. Then you also kindly come to this. They said they given the plot number 32 1B. You also
When
kindly.
you have applied for sanction?
I applied before what system, my lord?
19 January 2013.
Yes, yes, yes. Before that, we take the all my lord clearance.
No, you have as the document which has been submitted before this court today on behalf of the case
17 January 2013.
13.
Yes, before that we take the
But the KIT letter is dated 22.
Yes, before that we take the clearance. We should take the all clearance.
All?
So we should take the clearance before submission of the plans. So KIT said no, it is KIT land, my lord. Then, my lord,
So if it is a KIT land, then on what basis you made an application under section 393?
I'm showing, my lord.
393 that this is your land.
I'm showing, my lord. You see,
No,
why?
please tell me.
My lord, when KIT, the next page is the answer, my lord. At page 75, immediately
Who is Jointona?
Is my LBS or architect.
Yes.
It's my in one way. In connection with the above referred letter, this is to apprise you good self. The undersigned do hereby annexing some documents showing that ownership of the plot in question was always in the hand of the company, namely Mallika International Private Limited. First, the enclosed documents, a record of the Assessment Collection Department, Kolkata Municipal Corporation, showing Mallika International as owner of the concerned property, tax bill issued by the Assessment Collection Department, Kolkata. Third one, the document is not with me, is with Mr. Ghosh's line, survey observation report issued by the Chief Valuers Surveyors Department, KMC, in for the assessing number Mallika International against the said property. The sale deed executed between the petition interest of the company and the company on 6 March 2095. So when I asked he said simply that from the records it appears the KIT line. I have given all the documents to the chief engineer.
What are these documents?
Does
it come in your aid? Does these documents do this document come in your aid?
Sell deed.
Yes, if it is post vesting sale.
No, okay, that has this
post vesting sale. Where is your right?
No, you are absolutely correct. But here the
or if it is post acquisition sale,
here
where is your right?
You are also but here the situation is different. Why here this is not the KIT Act.
Banking upon as it appears from this letter at page 75 that the first record of the Assessment Collection Department of Kolkata Municipal Corporation with effect from 3rd quarter 2004-5 showing Mallika International Private Limited as owner of the concern. So therefore, you are banking upon that mutation.
Yes,
assessment.
You also
how does it improve?
You are absolutely correct. When they say
second tax bill issued, third survey observation report issued by the Chief Value Surveyor Department KMC in favor of assessee number of
yes.
Then sale deed.
Right, so the facts then I'll come. It's a facts. I can't suppress it. But what happened in 2012?
No, these are the facts, but whether the facts
then I show how they could show whether this is their land or not. I'm coming.
Issue hinges upon this.
This is KIT land or not?
You are a post acquisition purchaser.
This is not a situation here.
Then how you are?
It's not a situation. It's not a KIT acquired land. This is that I'll show you.
Yes.
It is not a KIT acquired land. It is not a KIT acquired land. That I'll show.
It is not a KIT.
Yes, I'll show it, my lord.
Come to the statement. Come to the crux of the issue.
My lord,
Instead of showing the documents relating to
yes,
mutation,
yes,
Mr. Rai,
yes,
this does not improve your case.
no,
Because mutation is nothing, only for
Yes, yes.
allotment of
my
certain
self
number
is,
and
yes,
payment of
yes,
tax.
yes, my lord.
So that will not help you.
Yeah, yes.
So therefore,
I'm obliged, man. So, my lord, now you are kindly straight come to page 83, the order. 83 order. Yeah, obliged, my lord. 83 order, my lord. The first they said the objection, second part, third paragraph, third and fourth paragraph is a vital.
Yes.
I just missed.
Yes.
On 12 March 1914, the undersigned order from joint inspection in the presence of Chief Valuer, Server E. Secretary KIT of the application Sri Om Prakash Singhania. Pursuant to that objection, joint was taken place and report was furnished by Chief Valuer in charge KIT, Chief Valuer Surveyor KMC, both. I have perused both the reports filed by the KIT and KMC, and after inspection of the record regarding premises and concerning both the reports, I am of the observation that as the property belong to KIT, no person should be allowed or caused any construction on these properties. So Joint Municipal Commission has arrived at the findings that this is a KIT line on the basis of the report of KIT officers and the KMC officers. Now you also can see the both the reports. You also kindly straight come to page 119. This is the report of the Chief Valuer KIT. I just place it. My lord, Deputy Chief Engineer, sir, my lord, the joint inspection, the relevant is the concerned land area in
Where? Page 119.
119 after 5 sentence. The concerned land area. The concerned, you got it, man? These are the inspection.
Yes, the
The concerned land area in question was surveyed by the inspection team where the illegal construction was carried out. All the can you see this line? All the documents related to ownership of KIT land had been shown to KMC personnel. They said to the officer of the KMC, they have shown all the documents to the ownership of KIT. But this is the said. And the line and question was to joint survey. Now you also can see the report of the KMC officers at page 118. As per direction authority of the concerned assistant engineer of this department inspected the site along with the officials of building department, assessment department, ex-engineer, official KIT, KIT official identified the plots where the construction building is progress, and this department issued the survey observation report against the said plot showing there in the abutting road. Survey observation report in no way declares the ownership. I declares only the abutting road on all sides as appears in the records. Hence, applicant for SOR must be SCC, which is in this case bearing SCC number against premises number being Mallika International. But these two reports,
But that is the document of the KMC.
I cannot point out it. So, my lord, the Joint Municipal Commissioner says, I relied upon two reports. One report is this 118, one report is 119. On the basis thereof, I have arrived at the findings, this land belongs to KIT. Now I am placed, your lordship, the page 119. 119 KIT says, we have produced documents related to ownership before the concern shown to the KMC personnel. They say. Only they say. They have not enclosed any document in support of their ownership. Why I say I can't by they say all the documents related to ownership of KIT had been shown to the KMC personnel. There's no document enclosed there. How suppose it is an acquisition, I'll come, my lord. Suppose they award, though this land, they can show the acquisition order, it's the award in respect of this plot. They have not annexed any document here. And that 118 KMC says, no, on the survey report, it is 83, my lord.
What steps you have been taken after receiving this letter at page 74? When the Kolkata Improvement Trust informed you that according to the above mentioned property is KIT acquired land,
The facts I'm trying to.
what steps you have taken?
Yes, sir,
Instead of taking this technical point, what steps you have taken after the
My lord-
communication dated 1st August 2012?
Your Lordship, can you see? Yes. Now, what happened?
When this was informed by the Chief Engineer, Kolkata Improvement Trust,
Man,
to the to the petitioner, then without knowing without examining the veracity of this letter, can you represent yourself as the owner of the lot while making an application under section
Your Lordship,
393?
can you allow me? Your Lordship,
No, please answer the query of the court.
what is the answer? What is
That page 74, come to page 74.
that I'm pressing.
No, I want answer from you.
Yes,
first.
70 point,
Yes.
70 was given to my engineer.
Yes, and wherein it has been informed that the chief engineer by the chief engineer Kolkata Improvement Trust that accordingly the above mentioned property is KIT acquired land in so and so.
I see.
Now,
I have to
now
inform you.
you are making an application under section 393 in 2014.
Your Lordship,
Please answer the query. I will hear you. No issue. But please answer the query. In 2013, you made an application for declaring yourself as the owner.
Yes.
Owner based on the sale deed. Now, what steps did you take after receiving this
That
letter
I-
first
that-
August
that-
2012?
That time submit facts to your Lordship.
Come prepared. Next
I'm
day.
prepared, absolutely prepared. I'll take this matter, my lord. But I'm prepared.
Yes, today there is no time.
And take after, my lord,
Yes.
after 2 o'clock. My lord.
No.
My lord, you are certainly appreciate. I'll go back again. My lord.
It will be on next Monday.
Monday,
Writ
my lord.
petition is heard in presence of the learned advocates representing the parties.
No, Monday, yes.
Stop. Next paragraph. List the matter under the same heading for further consideration on Monday next, comma. February 2023. Come back.
Can you first apologize me?
No, it's not a question.
Sorry, my lord.
Act line add karo. Pursuant to the order dated 15 January 2024, Mr. Alok Kumar Ghosh, Learned Counsel, representing Kolkata Municipal Corporation, has placed before this court a copy of the application seeking sanction plan under section 393 of the Kolkata Municipal Corporation Act 1980, and the same is taken on record. Stop. Copy of the said sanction plan has been handed over. Has it been given?
Letter for sanction. Letter for sanction.
Has it been given to you?
Yes, yes.
The copy of the said application.
Proposing for
The
sanction.
copy of the yes.
This is an application of proposing for sanction of the plan.
The copy of the said application seeking sanction plan under section 393 has been handed over to Mr. Rai, learned advocate, representing the petitioner during course of hearing. call the list.
Item number 8.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. Same situation prevailed on 22nd January 2024. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Interim order of any stands vacated. Urgent Xerox certificate copy. চলো না এটা মিলবে না অঞ্জনকে বলো যে সিএলটির যে কপিটা সেইটা দিতে এখানে মিলবে না ক্যালকাটা ল টাইমস 2014 যেটা সেটা দিতে হবে আর নাহলে এক কাজ করো তুমি এখান থেকে নিয়ে নাও ওটা দিয়ে দেবে অঞ্জনকে এটা এখান থেকে খুলে নিয়ে বাকিটা আমায় দাও এইটা থেকে পাবে আবার দিয়ে দেবে আমাকে Yes, call the list.
Item number 9.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, Tamlulipto municipality is represented by learned advocates. Stop. Next paragraph. Same situation prevailed on 22nd January 2024. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Interim order of any stands vacated. Urgent Xerox certificate. Next.
Item number 10.
ওটা ফেরত দিয়ে দেবেন At the time of call, no one appears for the petitioners and no accommodation is prayed for. Stop. Same situation prevailed on 22nd January 2024. Stop. It appears petitioners have lost interest. Stop. Writ petition stands dismissed. Interim order finished stands vacated. Urgent xerox certificate copy. Application, comma, if any, stands dismissed. Application, comma, if any pending, comma, stands dismissed. Next.
Item number 11.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Same situation prevailed on 22nd January 2024. Stop. Next paragraph, it appears petitioner has lost interest. Writ petition stands dismissed. Interim order finished stands vacated. Urgent xerox certificate copy. Next.
Item number 12 and 13.
At the time of call, no one appears for the petitioners and no accommodation is prayed for. এসো এটা দুটো রিট পিটিশনের উপর যেরকম ভাবে অর্ডারটা করা আছে সেভাবে করবে পিটিশনার্স স্টপ আচ্ছা সেম সিচুয়েশন প্রিভেলড on the last date when both the writ petitions were taken up for consideration. Stop. Next paragraph, it appears petitioners have lost interest. Stop. Writ petitions stand dismissed. Interim order finished stands vacated. Urgent xerox certificate copy. Next.
Item number 14.
I beg to appear on behalf of the private respondent, my lord.
Order passed, sorry. Whether the affidavit has been served upon you?
No, my lord.
Please, Mr. Sureka.
My lord, Mr. Suraka is in court number 35. He's coming. Kindly pass it over.
Private respondents to file
No direction upon the HMC to file affidavit.
File report, my lord. Yes. My lord, in this matter, I am appearing along with my junior for the private respondent.
Well, pass over. Inform Mr. Sureka.
Great.
Next. Pass over it. Pass it off.
Item number 15. Item number 15.
Lord, I am appearing for the Lord Uttarpara Court Room Messuity with Mr. Rajiv.
My lord, as per your lord,
Just a minute.
বলছে কপি দিয়েছে আগের দিন ডাইরেকশনের কপি টপি সব দিয়েছে পরে
Yes.
as per your lordship direction on 15/1/2024, your lordship direct me to inform the learned advocate appearing for the municipality that this matter would appear on today. I have already.
Yes, he is appearing. What is your matter?
Fact is that illegal construction has been made just beside my house. Against that, I came before this honorable court. At first, when I filed previously I filed a writ application. At the time of filing writ application, the opposite party, the municipality submit that opposite party file an appeal. The appeal with regard to the same point that whether this property plan is sanctioned or not. My lord,
Who filed appeal?
Now the 7 to 10. Now
They preferred appeal against the order of the municipality.
Against the municipality. We appear on
What was the order passed by the municipality?
Municipality has not been sanctioning their plan. That's why they
Preferred appeal.
They applied for deemed sanction. Against that, this honorable court has not granted the permission for deemed sanction. Against that, they prefer an appeal.
Before the division bench?
Before the division bench. The matter came up before, as his lordship then was, my lord Justice Vishwanath Somadar, where we have appeared and we have filed an application for addition of us as a party. There, the court, this court direct that plan should have been sanctioned. Plan should have been sanctioned, and plan should have been sanctioned as per the rules now in days. And they have, my lord, I have annexed all the orders, my lord.
My lord, kindly come to page 125.
Is there any West Bengal Municipal Act 1996?
Previously. Thereafter, it has been modified by 2007.
After 1993 Act?
After 93 Act.
Yes, Mr. Mukherjee, is there any statute named West Bengal Municipal Act 1996?
No. Rules.
Come to your prayer. Page 50. Read prayer A.
1996, there was an act.
Show me that act.
Well, we say 1993.
Withdraw a writ petition file afresh.
My lord.
I am asking you, you are saying no, there is a statute.
I'm praying for apology.
Withdraw a writ petition.
My lord.
How the prayer can be molded or amended?
My lord, the word has been, there is a typographical mistake, my lord. It should be 1993.
So how this can be acted upon by this court? You should have been cautious while preparing the writ petition. By supplementary affidavit, the prayer cannot be amended.
My lord, it is your lordship the direction. I can make the correction.
No, prayer cannot be done in this fashion.
My lord, as per your lordship direction, I can make the correction on liberty.
This court cannot direct for amending the prayer.
Since 2018, the matter is going on.
What you have prayed for in this writ petition?
My lord, the plan should have been sanctioned as per building rule of 2007, and that has not been done. And they have made the.
You have not prayed for sanctioning of plan.
My lord, that's why.
Where are the private respondents? How you have served upon them?
My lord, previously they have served. They have already filed the opposition. I have filed the.
Show me the service upon them.
My lord.
Yes, door locked, envelope returned.
My lord, two of them was returned, and two they have received.
Yes, now you have prayed for cancellation of sanction plan.
My lord.
Dated 19 September 2018.
My lord.
On what basis you are praying for
On the
cancellation?
basis of RTI and on the basis of RTI, I get the information that the plan has been sanctioned.
Yes. So what is the ground for sanctioning the plan for cancellation?
That's why my lord, kindly come at first. My lord, kindly come. Page 126.
What is that?
My lord, division bench order. My lord, kindly come page 130, para,
Just him,
second para.
just him. How does it help you?
My lord,
How this order will help you?
my lord,
It is in favor of the private respondent Ratnaboli
in favor of
Ratnaboli
both.
Banerjee.
My lord, in favor of both, but there is
No, no,
direct-
not in your favor.
Yes,
Not in
yes.
your favor. You are trying to uh, uh, prevent the municipality from issuing sanction plan in favor of Ratnaboli Banerjee. Now the division bench has made it clear.
This is the point, my lord. What division bench has directed. My lord, kindly come page 130, second para. In such circumstances, these court direct Uttarpara Kotrang municipality, being respondent number 1, to sanction building plan to the applicant number 1 strictly in accordance with law means the law that is going on that day, the rule that is building rule going on that day, thereafter, preferably within a period of 4 weeks, but not within 6 weeks from the date of communication of a photostat certified copy of this order.
Where is the infraction of law with
Now,
regard to
now,
issuance of
now,
sanction plan?
Now, I am coming. My lord, kindly once come page number 108 RTI report. My lord, the third query number 3. When it was submitted.
Just a minute. Yes, 22nd August 2017.
17. My lord, what rule at that point of time is going on? 2007 rule, not the previous rule. My lord, now come this Honorable Court's order dated 18/12/2018. Devanshu Basak order in this matter, my lord.
Is he your friend?
My lord,
Is he your friend?
my lord, this is the order. This is the order.
Whether Justice Bosak is your friend? You are saying Devanshu Bosak?
My lord, Justice.
Where you have said? Now you are saying.
But I am always, my lord.
Be careful in submitting before this court.
My lord.
Yes.
My lord, kindly come to order dated 18/12/2018.
What for?
In the order itself, it has been mentioned. Needless to say that the construction made in terms of
18th order, 18th August 2018 order on which writ petition?
His writ petition.
Yes.
Under the last portion.
Just a minute. Yes. What do you want to submit on this order dated 18 December 2018?
What was the last portion?
Yes.
Needless to say that the construction made in terms of the impugned sanction will be abide by the result of the writ petition.
Yes.
My lord, so if the construction could have been made, that should have been made as per the regulation of the going on that day.
I am asking you simple thing. You have questioned the sanction plan dated 19 September 2018.
Man.
What are the grounds? Straightway come to those grounds. Because the sanction plan has been accorded in terms of the order of the Honorable Division Bench.
Man.
Your point is that the Honorable Division Bench directed that the plan is to be sanctioned strictly in accordance with law.
Man.
You are giving emphasis on this part of the order of the Honorable Division Bench, whereby Division Bench directed that the plan is to be sanctioned strictly in accordance with law.
Man.
Now, tell me or demonstrate before this court that where is the infraction of law?
My lord, first of all, from the RTI, I will show your lordship. RTI is attached. I am showing your lordship that plan has not been sanctioned as per the rule. Plan has been sanctioned beyond the rule.
How?
Now, this is the question. How? My lord, kindly come. RTI report dated page 112. RTI report. Height has been given 11 meter. and living space has been given 78.17. But rule says the road as has been shown over there, the height should have been 10.5 and living space should not be 75. If that be so, then FAR, floor area ratio, could have been changed.
How do you come to this?
My lord, municipality has
On
accepted
what basis you are giving this
on the basis of RTI.
this height and
RTI. In the RTI, municipality has himself submitted this.
where is the response to the RTI?
My lord, kindly come to page 112.
Now, where is the deviation according to you?
My lord, proposed height of the building is 11 meters.
Yes.
It should be, as per the regulation, it should not be more than 10.
Show me that regulation.
My lord, I mark, my lord, I have given the first of all, my lord, kindly come.
No, first of all, come to straightway to this that the height should not be more than 10 meters.
46.
No history, please. Come to the point straightway. Pay rule
46, page 50. My lord, first the maximum permissible ground coverage.
Yes, page 46, regulation 40, rule 46. Yes.
My lord, other use including mixed use. What is mixed use? My lord, kindly come page 10.
That is with regard to ground coverage.
My lord, I'm coming.
No, what
coming
about the
to
height?
this point
What
also.
about the height?
Height,
You
my
are
lord,
saying that it should not be more than 10 meter. Where from you are importing?
just next table 3 to 5 meter.
Next table means?
Just my lord, this table.
Under which rule?
This rule.
Under which rule? Rule number?
Rule number 49.
Rule number?
49.
Yes, show me the relevant part of this rule which has been violated.
My lord, table. Portion is table.
Prior to that, show me the provisions. Table will come later.
Height of the building shall be vertically distance measured from the average level of the center line of the adjacent street. This is the point. So, adjacent street is how much away?
The vertical distance. What is your instruction, Mr. Mukherjee?
No, in this matter, my lord, I have no instruction in this particular regard.
You have not filed any affidavit.
I have no affidavit has been filed.
He is saying that the affidavit has been filed.
Private
My
respondent.
lord,
Private respondent filed.
my lord, kindly come to affidavit in opposition. They have admitted this fact. Kindly come to affidavit in opposition filed by respondent number 234. My lord, kindly come to page 10, para 25. Affidavit in opposition on behalf of the respondent number 2, 3, and 4. Chairman.
Calculations must be on the basis of measurement. Court cannot do this. So you have prayed in prayer B for consideration of your representation. Let it be considered and an order be passed. You have prayed for, pray come to prayer B. Court will not go into this calculation part. Come to prayer B. Page 50. Dispose of the application made by the petitioner in 19 November 2018. Let it be considered by the authority and pass an order after granting opportunity of hearing to the petitioner and the private respondent.
My lord, they have themselves admitted.
Where is your annexure P21?
P21, my lord. Page 148.
It is a demand notice.
My lord. Now, my lord, kindly consider the admission made by the municipality himself.
Issue.
My lord, once, my lord, kindly consider
The writ petition
admission made by the municipality himself.
in the writ petition, challenge has been thrown to the to the sanctioned bill plan which has been accorded in favor of which respondent? Ratnabali Banerjee?
My lord, 4. Respondent number 7 to 10.
But it appears it is in favor of 9. Ratnabali Banerjee.
But my lord, they from the development agreement.
No, I will go by the order of the Honorable Division Bench.
My lord, in the division bench, they have all appeared.
No, but there is a direction that if the dispute is against Ratnabali Banerjee. Respondent number 9.
But my lord, Ratnabali Banerjee was the 1, 2 is the Shankar Sinha, and 3 is the Aditya Shankar Samantur.
Come to page 129.
He is one of the owner of the property, one of the owner. There is 2 owners.
Come to page 130.
My lord.
Read it. First paragraph, page 130.
Appellant number 1.
The added respondent objects to the
sanction of the plan in favor of the appellant number 1 on diverse ground, which includes that the plea that no partition has been affected. My lord, this is my point.
According to us,
has been affected in respect of the plot belonging to the appellant number 1 and that of the added respondent. According to us, these grounds cannot be basis of refusing the sanction of the building plan submitted by the appellant number 1.
Appellant number 1.
But my lord,
and particularly when the respective deeds have a sketch map showing the 2 plots are demarcated, and so long as appellant number 1 is seeking to make construction on her demarcated plot of land.
But my lord,
in such the court directs Uttarpada Kottayam municipality being responsible to sanction building plan to appellant number 1. Why you are trying to enhance the scope of the writ petition?
My lord,
don't make wrong submission before this court.
I'm not making any submission against that. My lord, they have filed the
writ petition. Writ petition.
Development agreement. In the development agreement, they show that 2% was the owner of the property. My lord, kindly come to the development agreement once.
अच्छा की बोललाम in favor of Ratnabali Banerjee, comma, being respondent number 9. In spite of service of notice upon the respondent number 9 and other private respondents, those respondents are not represented today. Stop. Affidavit of service was filed on previous occasion, wherefrom it appears
My lord, the municipality in their opposition admitted that 2007 rule has not been followed. They themselves has admitted this fact.
two of the private respondents have received the notice but respondent number 9, but from respondent number 9, and 10, envelopes have returned with an endorsement unclaimed, quote unquote. Now, with endorsement unclaimed, quote unquote, and addressee moved, quote unquote, respectively. Next paragraph. Therefore, the writ petition is taken up in absence of representation on behalf of the private respondents. Stop. However, Uttarpara Kotrong municipality is represented by learned advocate. Stop. Next paragraph, the learned advocate representing the petitioner. Represent the petitioner submits a plan, a sanction plan was submits a plan was sanctioned in favor of the respondent number 9 on 19 September 2018. Which is dehors the West Bengal Municipal within bracket building close bracket rules, 2007. In connection with attention of this court has also been drawn to the order of the Honorable Division Bench dated 30th July 2018, whereby Uttarpara Kotrong municipality was directed to sanction building plan in favor of the respondent number 9 being appellant number 1 therein, strictly in accordance with law, within a specified time. Stop. It is contended on behalf of the petitioner that in spite of giving such direction upon the municipality to sanction plan strictly in accordance with law, on violation of the relevant provisions of the West Bengal Municipal within bracket building close bracket rules, 2007. Plan was accorded on 19 September 2018. Stop. One demand notice has been preferred on behalf of the petitioner dated 19 November 2018. Questioning sanctioning of plan in favor of the respondent number 9 on 19 September 2018. Next paragraph. In view of the aforesaid submissions made on behalf of the petitioner and taking note of pendency of the demand notice before Uttarpara Kotrong municipality, whereby according of sanction plan dated 19 September 2018 in favor of respondent number 9 has been questioned, comma, the concerned authority of Uttarpara Kotrong municipality is directed to take decision on the said demand notice dated 19 November 2018 within a period of 12 weeks from the date of communication of this order, and to decide the validity of the sanction plan dated 19 September 2018 issued in favor of respondent number 9. Stop. Before taking decision, opportunity of hearing shall be granted to the petitioner as well as respondent number 9 or their representative. Stop. The reasoned decision to be taken by the concerned authority of Uttarpara Kotrong municipality shall be communicated to the petitioner within 1 week thereafter. Next paragraph. With the aforesaid direction, the writ petition stands disposed of. There shall be no orders to costs. Urgent Xerox. Grateful. Decision to be taken within 12 weeks. Date of communication of দিয়ে দাও। হ্যাঁ, আচ্ছা, এটা নিচে একটা লেখো, affidavit of service filed on behalf of the petitioner today is taken on record. Next.
Item number 14, passover matter.
Your Lordship, in this matter, I tender apology, Your Lordship, because Mr. Banerjee was following up with the HMC officials, and we were Mr. Sandipan Banerjee was following up the matter with the HMC officials. We were directed by this honorable court to annex certain documents, and specifically the retention fees order which has been passed, Your Lordship, for the proper adjudication of this case. But however, due to he has some personal functions in the family, Your Lordship, the matter could not be followed up. It is our fault on our side, Your Lordship. If Your Lordship may be pleased to
issue affidavit, the learned advocate, the learned advocate representing Howrah Municipal Corporation has prayed for extension of time to file affidavit in terms of order dated 18 January 2024. On the ground that the learned advocate representing Howrah Municipal Corporation has some personal difficulty. So, however, Petitioner and other respondents are represented to petitioners and other respondents are represented to the stop. Next paragraph, hearing of this matter stands adjourned till
বাড়িতে দিয়ে আসে মেয়ের বিয়ে আছে বাড়িতে এই বুধবারই আছে
Fifth February.
Your Lordship, may it be 7th or 8th after 6, Your Lordship. Yes, please.
After 6.
6, Your Lordship.
Then 12th February 2024. In order to enable Howrah Municipal Corporation to file affidavit. Next.
I apologize. Your Lordship, it was.
Next. Common list. Personal difficulty of the advocate.
You don't do that English. Offline.
Item number 113 from appellate side, monthly cause list.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. Next paragraph, by order dated 16th May 2018, a coordinate bench directed the parties to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph lists the matter under the heading hearing, group 5, municipality for disposal on 5th February 2024. Stop. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next.
Item number 114.
At the time of call, no one appears for the petitioners and no accommodation is prayed for. Stop. However, Howrah Municipal Corporation is represented by learned advocates. Stop. Next paragraph. List the matter under the heading here. Under the heading motion, Group 5, municipality for disposal on 5th February 2024. Stop. However, it is made clear if on the urgent date petitioners go unrepresented, consequential order shall be passed. Next.
Hundred and 15.
Well, regarding item number 14, Mr. Sureka is there.
Yeah, for
For the Howrah Municipal.
Howrah Municipal Corporation.
On the last occasion also, your lordship, they were not interested. 2017 order shows.
At the time of call, no one appears for the petitioners and no accommodation is prayed for. Stop. However, Howrah Municipal Corporation is represented by learned advocates. Stop. Next paragraph. List the matter under the heading Motion Group 5 Municipality for Disposal on 5th February 2024. Stop. However, it is made clear if on the urgent date petitioners go unrepresented, consequential order shall be passed. Petitioners. Next.
116.
Who is appearing? Where is he? Where he has gone? Issue. At the time of call, accommodation has been paid for on behalf of the petitioners. However, no one is representing the respondents today. Stop. Next paragraph. List the matter under the heading Hearing Group 5 Municipality for Disposal on 5th February 2024. Stop. Next paragraph. However, it is made clear. Why? Let him remain out of the station. কি বলছিলাম? However, it is made clear if on the adjourned date petitioners go unrepresented, no further adjournment shall be granted. Now, however, it is made clear that no further adjournment shall be granted. Next, first senior will be out of station, then junior has difficulty, and the matter will go on in the list. Next matter.
117.
You are for the municipality. At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. However, municipality is represented by learned advocate. Stop. Next paragraph. By order dated 6 July 2018, a coordinate bench directed the parties to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph. List the matter under the heading hearing group 5 municipality for disposal on 5th February 2024. Stop. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next.
118.
At the time of call, no one appears for the petitioners and no accommodation is paid for. However, next paragraph lists the matter under the heading motion group 5 municipality for disposal on 5th February 2024. Stop. However, it is made clear if on the adjourned date petitioners go unrepresented, consequential order shall be passed. Next.
120.
Disposed of. কি করে? Yes, next.
120.
At the time of call, no one appears for the petitioners and no accommodation is paid for. Stop. Next paragraph lists the matter under the heading motion group 5 municipality for disposal on 5th February 2024. Stop. However, it is made clear if on the adjourned date petitioners go unrepresented, consequential order shall be passed. Next.
Hundred and 22.
Respondent, number 6.
The APT, there is a direction to file APT opposition. I have also hard copy. Reply also filed opposition. Water connection, madam. Yeah, madam.
Order 220 is also.
Program corporation is required, madam.
You have for
Yeah, for respondent number 6.
private respondent. Private respondent.
Private respondent. You are the credit pilot, usually respondent number 6.
Just a minute. Affidavits are complete?
Complete. So far as the private
You file reply?
yes, yes. Private respondent affidavit.
Do you want to use an affidavit?
Your Lordship, possibly a report must be there with me because this is a change in brief. Your Lordship, Mr. Biani used to appear in this matter. Your Lordship, if Your Lordship wishes, I can come with a report at least about the present situation. Then the matter can be decided. No formal affidavit may not be required.
Matter relates to water connection.
Your Lordship.
So therefore come with a report.
Whether the resolution has already been done or not, what is the present situation, Your Lordship, for that, if a report is. Kindly see the affidavit position by the annexure 1.
The matter is taken up for consideration in presence of the learned advocates representing the petitioner, Howrah Municipal Petitioners, Howrah Municipal Corporation and respondent number 6. Stop. An affidavit in opposition has been filed on behalf of the respondent number 6, which is taken on record. Stop. Next paragraph. Since no affidavit has been used on behalf of Howrah Municipal Corporation, Mr. Sureka, learned advocate representing the corporation, has prayed for leave to file a report. Report. Stop. Next paragraph next paragraph in view of aforesaid submission made on behalf of the corporation, how concerned authority of Howrah Municipal Corporation is directed to submit a report within 2 weeks from date.
3 weeks maybe.
By 2 weeks from date, if necessary, after causing inspection at the local. Stop. List the matter under the heading hearing Group 5 municipality for disposal on February 19th, 2024 for further consideration. Why I have not filed up till now? Again, I have to add a line. যেখানে affidavit in opposition বললাম, affidavit in reply filed on behalf of the petitioners is also taken on record. Next.
One thing,
let them file a report, come back on the next date. Let me see.
The representation application of already been decided by the municipal authority.
Very well, let them file a report.
He does not want water connection in his building.
Let them file a report.
Prior to filing of the
shall I direct to effect supply of water upon the petitioner?
No, my lord. They are.
Shall I direct here and now to supply water?
Already they are prayer rejected.
Next matter. 123. How this matter has come up before this court? It's a group 2 education matter. This court does not have determination.
Group 2 education matter, my lord, it is related to municipality schools.
But you have filed this writ petition classifying the writ petition as group 2 matter.
Well, group two, actually group two, as because the well, the matter relates to the municipal school, municipality Bidhannagar, that's why it was released by the coordinate bench,
Let me see by which court.
by the court number Justice Aniruddha
My lord,
Rai.
on the basis of my instruction, I have submitted.
Just a minute.
Yes.
Don't justify your presence. Wait for some time.
No, my lord.
On 12th December, it was released.
Justice Samanta has said that this court does not have determination since this writ petition pertains to secondary education.
Kindly see the order dated 12 December 2023.
This is fine.
What you are praying for?
My wife was the teacher under the Bidhannagar Municipality Corporation School.
Primary school or secondary school?
Initially,
Secondary
primary.
school.
Initially,
Justice
primary,
Samanta said is
thereafter, it has been shifted to the State Administration Municipal Schools. Now, the gratuity amount I prayed for. What is the why it is really why it is not released? I made an application RTI Act.
But any matter relating to education is to be heard by the
that's
regular bench.
That's my lord. What
Not
can
a,
we are, that
if
is
it is a corporation school matter, it is to be heard by the corporation.
repeatedly I submitted before the coordinate bench on 12th. It is matter relating to
দেখি এক
schools.
মিনিট কমন লিস্ট এখানেই আছে।
No, your lordship's well group 2 matter, your lordship had no jurisdiction. It should be the my appointment
If
under
the
the
issue, suppose a school
yes
is in order to construct a new building has prayed for sanction of plan
right
before the municipality, then that will not be considered as an education matter. That will be
when I am in
considered.
schools
Yes,
that
you are
will
praying for appointment on compassionate ground.
yes, that is certainly it is group 2.
Yes.
I have tried my level best. One of the it was not taken up. It was released.
Asansol municipality matters.
Yes,
Lot of education matters are there. There are schools under Asansol municipality. These matters are to be heard by the education bench.
That is my understanding.
বলো কিছু, অন্য কিছু বলছো না? তুমি আমাদের কিছু বলো, কোথায় হবে বলো, সেটুকু বলো। একটু কি হওয়া উচিত? সেদিন কি বললে? মিউনিসিপাল ম্যাটার। না সেদিন বললো আমার, হ্যাঁ জজ সাহেব বললেন, আমরা তো কিছু বলিনি। আচ্ছা
Now the administration of the school is controlled by the municipality.
Municipality.
মিউনিসিপালিটি কে নোটিশ দিয়েছেন?
Which municipality?
বিধাননগর।
Bidhannagar.
Bidhannagar Municipal Corporation.
Bidhannagar Municipal, yes. The school is the Bidhannagar Municipal School.
I am hearing a matter of Dhulian municipality regarding en masse cancellation of engagement of Shahikas.
Sohika is a different thing.
So therefore, very well I will hear it.
Then, well, it is, your lordship kindly pass.
Serve notice upon the municipality, Mr. Shishyanno Bandyopadhyay appears for Bidhannagar Municipal Corporation.
Very.
There is no use of releasing the matter by
No,
one
no,
after another
unnecessary,
court.
my lord,
Ultimately, matter will not be heard. Instead of getting into technicalities, it is better to take up, since the Bidhannagar Municipal Corporation is the appointing authority.
Appointed.
Whether there was a direction for any affidavit?
No,
previously.
No, no.
How it was admitted?
Direction to chilo na.
No, it's a motion direction.
The lordship kindly pass necessary direction. Adjourn it. I will serve the notice. Let it be.
Whether any order has been passed by the authority rejecting your claim?
No, no, no. I am constantly making applications. Kindly release that amount. And what I made an application under RTI Act. What is the reason for delay? My advocate's letter was given. No response. Or your lordship can direct them to file a report.
Oh, you have prayed for terminal benefits.
Yes. Let them come and let them come. What is their stance? Let them come.
Issue. The writ petition relates to release of arrears and gratuity due to death in harness.
Death in harness.
Due to death in harness of the husband of the petitioner, who was
wife of the petitioner. Husband is before your lordship.
Petitioner's wife. Due to death in harness of the wife of the petitioner, who was a teacher.
No, the assistant teacher.
Who was an assistant teacher of a school controlled by, who was an assistant teacher of a school under the administered by Bidhannagar Municipal Corporation. Stop. Next paragraph. Today, petitioner and the state respondents are represented. Stop. However, no one is representing Bidhannagar Municipal Corporation. Stop. Next paragraph. The learned advocate representing the petitioner is directed to serve notice upon the Bidhannagar Municipal Corporation or the learned advocate who usually represents the corporation, enclosing copy of the order passed by this court today by February 2024 and file affidavit of service on the adjourned date. Stop. List the matter under the heading motion municipality group 5 municipality for disposal on 5th February 2024.
5th is a combined list. 5th will be combined list.
This will be at a, when this court is giving direction, it will be
no problem
at the top. এটা কম্বাইন লিস্টে কি মানে তোমার ইউজুয়াল হেডিং চলে যাবে মোশন
29 হ্যাঁ 29 নেই
very well on 12th February
12th
combined list there will be a difficult
that's
বিএমসি আছে এখানে
না 12th February অনেক পিছিয়ে
হ্যাঁ ঠিক আছে ও না দিন অপেক্ষা করেছি আর কি করব
এই বিধাননগরে আছে এটা তো হ্যাঁ একটু আমাকে
Next.
ও আচ্ছা আচ্ছা
I am from the Vidhannagar
ও
Municipal
তুমি আসো তো বলো
দাও দেখি এই বিপ্লব এসো
তাহলে তো
সার্ভিস সার্ভিস
তাহলে সার্ভিস
টু টেক
দরকার
ইনস্ট্রাকশন এসো নোটিশের দরকার নেই এসো।
হ্যাঁ
অর্ডারটা কেটে দাও না প্রথম পার্টটা ঠিক আছে দেখো ওই ফ্যাক্টস অফ দ্য কেস বলেছি হ্যাঁ ওইখান থেকে আবার parties are represented today. Stop. The learned advocate representing Vidhannagar Municipal Corporation has prayed for accommodation to obtain instructions and to file a report.
yes that will be
Obtain instructions and to file a report.
I need a copy.
Next paragraph. Let a report in the form of affidavit be filed by 2 weeks from date with an advance copy upon the learned advocate representing the petitioner. Stop. Next paragraph. List the matter under the heading Motion Group 5 Municipality for disposal on 19th February 2012.
12 your lordship directed 12
Let it be there. Court may not be available during that period.
circuit
So 12th or 19th, that will not make any difference.
that's true
ব্রিফটা দাও 19 জানুয়ারি
Item number 124.
সরি
মাথাটা গেছে
19
বাবা কি করছো কে বোঝাও
হ্যাঁ
কোনটা 12 কত নম্বর আইটেম এটা হ্যাঁ 2107 disposed or dismissed matter আমার অর্ডারে কি করে দিয়েছি Next matter. One 125.
125 last in this
but
matter.
I'm for the municipality.
You are for the petitioner.
Last occasion was there is a direction for filing another substitution application.
Another?
Substitution application. One application we have filed, but lordship another substitution application we could not lordship gather the details of the lordship that person lordship. That's why lordship I am seeking lordship this month time lordship.
Copy down.
Is it
Copy application.
substitution deal? অ্যাপ্লিকেশন ফাইল করতে আসলেন ডিটেলস পাচ্ছেন না সব চলে গেছে
এখানে লিখে দেয় পিটিশন দুজন দিন ওরও আছে আমার আরো আমি রেসপিরেটরি
Item number 125.
125 네. 네, 보시네. 막,
But this order was passed on 18th August 2023.
What happened?
What more time is required for substitution so far date of respondent number 6 is concerned?
Most of the lordship, the respondent lordship left the place. They are.
What is the matter about? Let me see.
Can you allow?
Place your matter. Forget about the date of respondent number 6. Place your matter.
Can we take it? Lordship?
Let me see what is the prayer.
Prayer lordship for removal of the illegal construction lordship by blocking one of the irrigation issues of the petitioner.
Where is your representation?
29. P7, page 29.
Yes, page
29,
Right.
P7.
29.
Page 29, P7.
During pendency, another person will die. And this process will never end.
Of the private
Yes,
petitioner
yes,
not
yes.
residing at the place. That's why lordship the name of the legal acts.
If you are not in a position to collect the particulars of respondent number 6 within last 5 months, you won't be able to collect the particulars in the next 5 years. So therefore, it's better to consider the merit of the writ petition.
ইয়ে দেবো গিফটই নেই তো কাজে
বলুন না আপনি পরের দিন
কদিন নিয়ে তাহলে
Can you take it tomorrow lordship?
No, sorry.
Evening.
Tomorrow is not the date for taking up municipality matters.
Any day lordship next week or convenient to your lordship. Lordship today lordship brief is.
Let us read the brief together. I am also not aware of the facts of the case. Please read the brief and place your facts.
Lordship, my brief is not with.
But, Mr. Bhattacharya, give the brief. Yes.
এই তো দিতে হবে আমার একটাই কপি আছে এই আমার কাছে আছে।
তারপরে রিসিপ্ট পাঠিয়ে সেখানে লিখে তাহলে
ঠিক আছে
কাস্টমার মিউনিসিপালিটি সার্ভার এই যে রূপ করবে আমি লক্ষ্মী দত্ত এটা ওর রিপ্রেজেন্টেশন মানে সবার কাছে অভিযোগ ওটা অ্যালিগেশন অ্যাপ্লিকেশন সাবমিট করেছে
Page 27 and lordship.
Wait.
27.
Wait.
Twenty-seven, 37.
ঠিক আছে ওই যে দশটা অসীম municipality. আমায় একটু বলুন একটু
I'm relegating the matter back to the chairman of the municipality based on this demand notice, which is
Page 29.
at page 29, and to take a decision. Since the case has been made out that the permission has been accorded in favor of the petitioner to repair work, which has been obstructed by the private respondents, and pass a necessary order and ensure that if the permission was previously accorded, the petitioner can make necessary repairing work.
Pursuant to the order of this our court, the chairman, the municipality, has made inspection and it's submitted a report to me in my name. This is kind.
Yes, what is there?
Yeah, I'm reading that also. As per the said correspondence stream, office visited the residence of Sri A.K. Dotto on the stipulated date and time, and the observation are as follows. Sri A.K. Dotto constructed brick wall, lintel, RCC casting, roof and beam, window opening, wall, plaster, etc. in the northwestern side of ground floor of his residence without having any approved plan and estimate from this office. This may also be stated here in this connection that the following person have also constructed their residence without obtaining any approved plan and estimate from the office in an illegal manner, which has also came to the notice in course of visit of the inspection team of this office. That is
That the following persons means the private respondent.
Yes.
So whether let the matter be revisited again by the chairman, a person reasoned order.
Yes.
Issue.
Another thing, Lordship, the gate which
Writ petition is taken up for consideration in presence of the learned advocates representing the petitioners, Katwa municipality, and the state respondents. However, no one is representing the private respondents today. Stop. Next paragraph. It has been submitted on behalf of the petitioners that the premises of the petitioner stands on plot number 4092 and 4094, having 5 and 4 decimal of land respectively, which has been classified as VT, VITI, VT and Vastu.
Yes.
VT and Vastu. The aforesaid 2 plots of land were purchased by the petitioner by executing separate conveyance deeds, one in 2012 and another in 2014. Stop. It has been contended on behalf of the petitioners that upon obtaining necessary permission from the concerned authority of Katua municipality, when petitioner tried to make necessary repairing work, he was prevented by the private respondents, as a result whereof repairing work could not be made complete. It is also alleged that the private respondents are making unauthorized construction at their respective plot of land. Stop. Next paragraph. Having considered the contentions made on behalf of the petitioners and the submission made on behalf of Katua municipality, the writ petition stands disposed of, directing the chairman Katua municipality to hear the petitioner and the private respondents and pass a rescind order within a period of 12 weeks from the date of communication of this order. And to decide whether and to decide and to find out whether petitioner was previously permitted to repair his premises. Stop. If previously permission was accorded in favor of the petitioner, if permission was previously accorded in favor of the petitioner, necessary direction shall be made by the chairman, allowing the petitioners to complete his repairing work. Stop. At the same time, the chairman shall also look into the issue whether any unauthorized construction has been made by the private respondents without obtaining sanction planned or not.
Yes.
If it is found that the private respondents have erected unauthorized constructions, necessary order shall also be passed in order to prevent such unauthorized construction at the instance of the private respondents. So, however, there shall be no orders to cost urgent Xerox certificate. Next.
126.
126.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. Next paragraph lists the matter under the heading Hearing Group 5 Municipality for Disposal on 5th February 2024. Stop. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next.
127.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. By next paragraph, by order dated 29th January 2019, a coordinate bench directed the parties to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph, list the matter under the heading Hearing Group 5 Municipality for Disposal on 5th February 2024. Stop. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next.
128.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Next paragraph lists the matter under the heading Motion Group 5 Municipality for Disposal on 5th February 2024. Stop. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next.
Item number 129.
Hearing for the Kolkata Municipal Corporation. At the time of call, no one appears for the petitioner.
My lord, passes an order, may I submit? But on the self-same cause of action and between the self-same parties, another writ petition has been. On the self-same cause of action and between the self-same parties, subsequently another writ petition has been filed. Man, may it be tagged with this matter? Because the subsequent petition has a mention of this writ petition also.
Give me the particulars of the.
Yes, my lord. WP number 20003 W of 2019. Srimati Shikha Das and Kuku Das versus the Kolkata Municipal Corporation and others.
Issue. At the time of call, no one appears for the petitioner and no accommodation is prayed for. Next paragraph, by order dated 25th January 2019, a coordinate bench directed the parties to exchange affidavits. Stop. Next paragraph. Mr. Banerjee, learned advocate representing Kolkata Municipal Corporation, submits that on the self-same cause of action, another writ petition has been filed, being so-and-so, number so-and-so, which is pending before this court. Stop. Next paragraph. Let the aforesaid writ petition be made available on record before the adjourned date. Stop. Next paragraph. List both the writ petitions under the heading Hearing Group 5 Municipality for Disposal on
Or if it is after my lord's comeback, my lord, then I
26th February 2024. Stop. Next paragraph. The learned advocate representing Kolkata Municipal KMC is directed to serve notice upon the learned advocate representing the petitioner, including copy of the order passed by this court today by 7 days from date and file now. Respondent.
My lord has given the time, my lord, I have a sigh of relief because the report which was, the instruction which was handed over long back in 2019.
But serve notice by
000.
Serve notice by 7 days.
2003 মানে 20,003 2019
Serve notice.
Yes, yes.
Next.
Item number 130.
আমারটা দিবে
আমার জুনিয়র বলছে আপনি নামটা লিখবেন না, ভয় পাচ্ছিল। ঢুকিয়েছি বলছি আমার জুনিয়র ভয় পাচ্ছিল ওর দিকে ঢুকেছি তো হ্যাঁ ও তো আছে তোর ভোট করছিস না হ্যাঁ
At the time of call, no one appears for the petitioners and no accommodation is prayed for. Stop. Next paragraph lists the matter under the heading Motion Group 5 Municipality for Disposal on 5th February 2024. Stop. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Next.
Item number 131.
Yes, you are for the state.
I appear for the corporation. There appears to be an application for recalling of an order of January 2009. কে আমি আবার এত জোরে জোরে বললাম যে কর্পোরেশন
Allowed. That application was allowed. At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, Kolkata Municipal Corporation and the state respondents are represented by learned advocates. Stop. Next paragraph lists the matter under the heading Motion Group 5 Municipality for Disposal on 5th February 2024. Stop. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Next. Where is that?
132.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Next paragraph lists the matter under the heading Motion Group 5 Municipality for Disposal on 5th February 2024. Stop. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Next.
133.
This matter, I am appearing for the petitioner. This is a very old matter. Lordship will kindly fix a date.
Not a very old matter.
2019. Yes, yes. This is in respect to a plot of land, which is as in the record of rights, it has been classified as Bastu. But due to some rainfall, some water stagned, and municipality commissioner has councillor has made a complaint that I am making illegal construction without conversion. That is the only case, Well, I'll come back with all the.
The construction is complete.
No, nothing is there. No complete. Nothing. Well, we have not done any construction. Only dispute is in respect to that.
Any
Conversion.
proceedings under the West
4C.
Bengal Inland Fisheries Act?
West Bengal Inland Fisheries Act, Lordship knows, that has to be the water, has to be, for, appropriate for the fishery, but it is not. It is, I'll show you from the records, it is a Bastu since CS.
You have to the state. What is your instruction regarding the nature of the land owned by the petitioner?
At this state, brief is not available, Lordship. Kindly fix it in any date, Lordship.
2 weeks time, I am seeking before your Lordship.
Any private respondent?
My private respondent was there.
Issue. At the time of call, accommodation has been prayed for on behalf of the petitioner. Stop. State respondents are represented by learned advocate. Next paragraph. Learned advocate representing the petitioner is directed to serve notice upon the non-appearing respondents or the learned advocates representing those respondents, enclosing copy of the order passed by this court today by 10 days from date and file affidavit of service on the urgent date. Stop. Next paragraph lists the matter under the heading. There was a direction for affidavit.
Yes, yes. The BLRO has filed a report. We have filed an exception to that matter. Probably that was the only direction. If I recollect.
List the matter under the heading hearing group 5 municipality for disposal on February 2020.
Only one thing, probably state was only appearing before.
Serve and come back. Next.
Municipal.
Municipality also party.
Next paragraph, add a line. The learned advocate representing state respondents is directed to obtain instruction in order to disclose the nature of the land owned by the petitioners. Next. Single petitioner, more than one, they can. Next.
Item number 134.
I am for the petitioner, Lordship. My subject matter of challenge before your Lordship. Well, I am the owner of a dilapidated condition building, which is more than 100 years in Barakpur area. Now, the building has been collapsed. Due
to notice and come back. Today, no one is representing.
Well, previously, the municipal authority duly appeared before your Lordship.
Today, nobody is appearing. Therefore, you have to serve notice. You cannot move the writ petition cannot be heard ex parte. Serve notice.
Then Thursday, my lord. A very urgent matter, my lord. I am out of house since due to condition of building, my lord. I am.
The writ petition is taken up for consideration in presence of the learned advocate representing the petitioners. Stop. However, no one is representing the respondents. Stop. Next paragraph. The learned advocate for the petitioners is directed to serve notice upon the respondents or the learned advocates representing the respondents, enclosing copy of the order passed by this court today by 7 days from date and file affidavit of service on the urgent date. Stop. Next paragraph. List the matter under the heading motion group 5 municipality for disposal on February 2024. Next. Serve and come back.
Let it be 5th, my lord.
To serve and come back. Serve, let it be on 19th. Have you filed any application recently? Can 1 of 2023? What for? What is the prayer made in this that
View of the
application?
order passed by the Honorable Justice Tapobrata Chakraborty, my lord, a meeting was called for by the municipal authority. Now, we being the owner, we will represent ourselves, but the authorized, unauthorized occupants are there, they duly refuse to reach there. And the situation is this, my lord, the save and accept direction from the Honorable High Court to break the building by the municipal authority in view of the rules. I have no choice.
Come back.
135.
135, my lord, I am from the petitioner, my lord, I am praying for adjournment.
Why?
On behalf of Mr. Solil Maiti.
Yes.
Mr. Solil Maiti appearing in this matter, my lord.
Where is he?
He did not come to court today, my lord, personal difficulty.
Issue. The copy to the last matter. We are for the state. At the time of call, accommodation has been prayed for on behalf of the petitioner. Stop. However, state respondents are represented by learned advocates. Stop. Next paragraph. By order dated 20th March 2019, a coordinate bench directed the parties to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph lists the matter under the heading Hearing Group 5 Municipality for Disposal on 5th February 2024. Stop. However, no further adjournment shall be granted on the next day.
5th February, Lordship.
Yes.
Dada.
এই